Good morning, everyone. We are now starting with the moot court competition, and I now call upon Professor Amar sir to please introduce the judges.
Once again. Having practicing experience in the Bombay High Court since the year 2005, Sir is a criminal litigant in trial court as well as appellate court. Sir have represented several corporate entities, banks, as well as financial institutions. Some of the major cases handled by Sir are Sohrabuddin Sheikh encounter case, Lakham Bhaiya encounter case, NSEL scam, MPSC scam, etc. Now, I would like to introduce one more today's judge, Dr. Anil Gaikwad sir. Anil Gaikwad sir has been practicing in criminal side since so many years. Currently, he is a IC principal of Saugule Law College. Sir is going to join us very soon. Parik sir is going to join us within 1 minute and we will start it. Before that, I would like to request again a student in charge, Shreya Iyer, to read out all moot courts rules and tell us about today's schedule. Join us at top.
Each team will be given a time of 25 minutes. The following rules apply to both the teams. The pleading time will be of 10 minutes. The teams will be allowed to present their side for 10 minutes, where they can submit their opening statement, lay down the facts, explain the issues of the case, and prayer of the case. Every mooter can speak only for 5 minutes, and it is mandatory for both the mooters to speak. The witness examination time will be of 10 minutes. The participants can examine the witness for 10 minutes and they can examine all the witnesses in the list provided. Examination of the witness is segregated as follows. Examination of chief for prosecution, 5 minutes, and cross-examination by defense, 5 minutes. During defense examination, chief examination by defense, 5 minutes, and cross-examination by prosecution, 5 minutes. I repeat once again, examination of chief for prosecution, 5 minutes, and cross-examination by defense, 5 minutes. During defense examination, chief examination by defense, 5 minutes, and cross-examination by prosecution, 5 minutes. The time remaining in the witness examination would not be carried forward. The rules for rebuttal are as follows. 10 minutes will be allotted for rebuttal, and each team has 5 minutes, and this time cannot be carried forward. All the rules and regulations will be the same as mentioned in the moot proposition. Any disputes, concerns will be directly handled by Vidhi Taksh Organizing Committee. Vidhi Taksh management decision will be final and binding. Now team code VM1 and VM13, please be ready. Thank you. I repeat, team codes VM1 and VM13, please be ready. We'll be starting with the moot court competition in 5 minutes. Thank you.
तो पर्दा खोल नाही तो पर्दा त्या बाजूला कर त्या बाजूला हॅलो हॅलो हॅलो
I request Professor Amar sir to please introduce our judge, Mr. Gaikwad. Okay. When the next one. Stop rules again.
Yes, good morning everybody.
Gaikwad, sir.
Yes, I am there very much. I am waiting for you people.
Yes, sir. No, sir, I just request you to say a few words on this occasion before starting this session.
Okay. Yeah, I congratulate HVPC and Dr. Kalamkar madam for organizing this law fest, and I really appreciate that these kind of events must be organized every now and then by the colleges. And in the meantime, we have seen that there was 1 year which is passed wherein we couldn't meet student face to face, and the communication between the student and the teachers have become very less. But still, through this media, HVPS is continuously, I've seen that they've been doing the programs and they've been keeping in touch with the students. I really wish all the best to them for their future endeavors also. And I wish all the best to the students who have joined there today for this program and who would be appearing here for us for the moot court. Thank you very much to everybody. Yeah, over to you. Hello.
Thank you, sir, for your words of motivation. With your permission and Parik's permission, we can start the session. Parik, sir.
Okay.
Yes. Okay. So we'll start the session within 2 minutes.
There will be a 5-minute break right now. We will start with it, just getting ready with it. Okay.
Amar sir.
Amar sir, Amar sir. Yes, yes, Amar sir is here, sir.
Amar sir, Shraddha madam was supposed to be sending me the memorials on email. I haven't received it as of now.
Okay, okay. I will do it again, sir. Just a minute. Give us a minute.
Yeah.
VM1 and VM17, with the permission of the bench, start your proceedings. I repeat, VM1 and VM13, with the permission of the bench, start your proceedings.
नहीं नहीं पर्दा फुल तक क्या बोल
Yeah, we are
पूर्ण
ready.
क्या बोल लगा पूर्ण क्या बोल लगा open
I request all the other team members to please leave the meeting and join when your when the time of your schedule arrives.
I would instruct other teams except VM11 and VM1 and VM13 to please leave the meeting, as the first round is between VM1 and VM13. Rest are instructed to please leave the meeting currently and join as per the schedule. Did everybody hear the instructions? Except team VM1 and VM13, the rest of them are instructed to leave the meetings, except the judges. Please,
Sir, the other team members cannot be a participant to it.
VM11 and VM1 and VM13. Yes, VM1 and VM13, rest of them, please join as per the schedule provided to you. Rest of them, you cannot see the previous participants. Please leave the Zoom meetings. Except the judges, please.
हे घ्या ना त्याला बोलवा जरा प्रिंटआउट्स का नाही येते बघ जरा थांबा बघेन
With the permission of the bench, I would like VM1 to please start with the proceedings. With the permission of the bench, I would like VM1 to please start with the proceedings.
Yes, yes, go ahead.
Greetings to the honorable bench. Council seeks permission to address the bench as your lordship.
Yeah, go ahead.
Much obliged, your lordship. May it please this honorable court that I am the counsel for appellant in the case of state of Asta versus Sara and Manadar. Your lordship, the appellant will specifically be dealing with issue 1, whether the accused will be held liable under section 302, read with section 34 of the IPC 1860. Second, whether the evidence presented by the police is sufficient to hold the accused liable under section 302, read with section 34 of IPC. And the third, whether the statements given by the accused during police investigation is credible. Your lordship, issue 1 will be dealt by me and
You're not audible.
Speech, I think so. Ma'am, you weren't audible in the last 10-15 seconds of your speech. Please repeat it.
hello, am I audible?
Yeah, now it
Yes,
is.
counsel.
With your lordship permission, may the council proceed with the facts of the case.
Yeah, please.
Much obliged, your lordship. In the present case, the accused, Sara and Araz, deceased 6 of her family members, everyone except her 10 months old nephew Nal. Araz then chopped their heads off with an axe, while Sara held them by their hair. She throttled Nal, your lordship. After the death of all her family members, she was under the impression uh, that she will be the only legal heir of the property. Further, the evidence like blood-stained pillows, mattresses, quilt, and rope found near the respective dead bodies were dully sealed. And your lordship, the Sara and Araz were arrested. Recoveries of the murder weapon X and blood-stained shirt were made at the instance of Araz. And further, lordship Nokia mobile phone and empty strips of 10 tablets, blood-stained clothes, and the mobile SIM of Araz were recovered from Sara's possession. With your lordship permission, may the council proceed with the arguments advanced.
Yeah, please.
Much obliged, your lordship. The appellant humbly submits before this honorable court that the accused will be held liable under section 302, read with section 34 of the IPC, because the accused has a clear intention and motive for committing this crime, your lordship. It is said to have mens rea in the case of murder, where he has his purpose, that is intention. They had intention for committing this crime, your lordship. I want to draw your attention towards page number 1 of the fact sheet, second and third last line, where it is mentioned that Sara and Araz used to meet frequently, during which they discuss about their future and the resistance faced by their families. They mutually used to think of ways to resolve the issues in their families, your lordship. I want to draw your attention just about the second para, first line, where it is mentioned that the hardships she would face if she goes against the community, and wanted her to understand that Araz is not suitable choice for her. She will mostly end up quarreling with her family members, your lordship. Your lordship, family members used to fight frequently. Due to this, neighbors registered a complaint to the police. Your lordship, the facts here is very clear that the first Sara and her family members fight, and also her family members were short-tempered, which took that two accused to such serious crime as they were in love. And second, Raz and Sara used to meet frequently, in which they planned to kill the 5 innocent people. Because your lordship, right after this, Lala Khan entered the house and found the dead bodies. Your lordship, I want to draw your attention to how this serious crime happened and how the serious crime took place. According to the investigation officer, he found the fact that on the interviewing night of the April 14th or 15th, Sara sedated 6 of her family members, everyone except her 10 months old nephew. Then Aras chopped their heads off with an axe, while Sara held them by their hair. And your lordship, she throttled Nal. After the death of all her family members, Sarah was under the impression that she will be the only legal heir of properties. From this, we can easily get to identify actress Ria, your lordship. And when the neighbors arrived, she narrated the fake story of the group of robbers had attacked her house. And she was sleeping on the other side of the house. Her presence were not noticeable, as this was the statement given by the Sarah, your lordship. Here, I want to draw your attention towards the Sarah statement, as she stated that the group of robbers had attacked the house. Your lordship, the group word is mentioned, and when the group will attack the house, it is easily noticeable, or we can get alert. And your lordship, she stated that she was sleeping on the other side of the house. That's why her presence was unnoticeable. Why the group of robbers will leave Sarah room, your lordship? Let us assume that the group of robbers came first to their parents room and killed their parents, and then they moved to the adjacent room and killed her brother, sister-in-law, and nephew. Yes, your lordship, if we take the statement of Sarah that the group of robbers went to the parents room, even to the adjacent room, then why the group of robbers will leave Sarah room, your lordship? Under section 106 of the Indian Evidence Act, a heavy burden lay on the Sarah to explain as to how the deceased person had died in her house, as she failed to discharge this burden, your lordship. Sarah Araz worked in the wood saving company, so he had the reasonable knowledge with respect to X, your lordship.
Akib, tell them to type it in chat. Type it in chat.
Pardon, your lordship.
It was not to you, it was to the members. I think it was to the members, the notice that whatever
Okay,
you want to
much
say, type it in chat. You go ahead.
Much obliged, your lordship. Your lordship, I want to draw your attention towards the case of Kripal Singh versus State of Uttar Pradesh, where it is stated by the Supreme Court that the common intention may develop on the spot. Where after the offenders have gathered there, a previous plan is not necessary for the common intention, your lordship. Common intention can develop on the spot, and as to the crime can take place. Your lordship, under section 313 CRPC, she admits her presence by taking the stance that the co-accused Aras has committed the murder, and they implicated each other, as Aras stated that he was present, that he reached the house only on the request of Sarah, your lordship. We can easily identify the intention and the preparation of the accused. Your lordship, I want to draw your attention towards one more case of Bachchan Singh versus State of Punjab, where the reference to the constitutional bench raises a question in the regard to the constitutional validity of the death penalty, lordship, for the murder provided in section 302. During this, Supreme Court said that the death penalty will be only provided in the rarest of rare cases. Like capital punishment in India has been limited to the rarest of rare cases. It depends on the circumstances of the particular case, brutality of the crime, conduct of the offender, your lordship. Your lordship, as I want to draw your attention towards Exhibit A, page number 4 of the fact sheet. Here the FIR is reported by Lala Khan, but on the point 7 of the FIR, the details of the accused, that is mentioned Sarah and Aras. But as we come to the fact sheet, second page, it is mentioned that an FIR was registered.
2 minutes left.
FIR was registered against an unknown person. From this above points, we can easily considering the above points, your lordship, the council submits that the accused should be held liable under section 302, read with section 34 of the IPC.
Yes, counsel, you are relying heavily on the 313 statement of the accused. Can you just throw a light the admissibility of 313? Whether that 313 statement is admissible under the eyes of the law?
Your lordship, as the both the accused have implicated each other, that
No, that I've already heard about. My question is very specific, that whether the statement under section 313, which the prosecution is trying to rely upon, can be looked into. What is the admissibility of that particular statement? Is it sufficient?
Yes, your lordship, it is sufficient as the statement of the witnesses and the accused is admissible in the court of law, your lordship.
Are you sure?
Yes, your lordship, my co-counsel will be deal with issue 3, that is statements are credible or not.
Okay.
Much obliged, your lordship.
Sir, you're on mute.
Okay, in this case, I was telling you in 313, basically the accused are given the opportunity to explain his side, his alibi also, and the circumstances which he want to put forth before the court. And in your case, you haven't mentioned about any eyewitnesses or any other circumstances which may prove that the accused is really guilty. Do you have any other evidences apart from that?
Yes, your lordship, as all the evidences are against the accused, that is
It is only against the accused. But then any such important proof which will prove that it was only her and not other in the family?
Yes, your lordship, as the evidences were recovered from the Sara possessions, and the Aras also attempted to purchase the sleeping pills.
Okay, and
they were having the issues in their family, your lordship,
so
as
that
related to
doesn't.
Sara's marriage.
So that is the only inference which we can draw right now. Okay. Okay. The other any other questions by the other part?
See, your case is on the circumstantial evidence. You're supposed to connect the chain. Now you're relying upon the empty strip which was found. And at the same time, you're saying that the attempt was made by Aras for purchasing that particular pill. Now, attempt is not completing the offense. Right?
Yes, your lordship. Indeed, your lordship. But as we can see that the case has the intention and motive to prove this
See,
happened crime.
even to draw to that particular inference of motive, you need something substantive. Anyways, we'll deal with your second counsel. Let us hear him. Okay.
Much obliged.
Okay.
My lordship, I am the speaker too for the appellant side. I will be dealing with the issues whether the evidences presented by the police in the court are sufficient to hold the accused liable under section 302, read with section 34. My lordship, as you questioned my co-counsel here about the motive, here Sara and Aras, both of them had they were the only ones who had the motive to commit this crime. As the legal heir of the property, Sara, there is no one in her family to give in this property and all the other stuffs to anyone. And my lordship, the fights used to take place every day. The same nuisance was complained to the police by the neighbors, and it is mentioned in the
within the family, right? The fight was within the family.
Yes,
my lord. So it can be vice versa, right? So who was actually fighting? Who was notorious? These all questions need to be answered. It is none of the neighbors have complained that it was only the accused person who used to fight constantly with the family members. All they
My
have to
lord,
say
it
is that
is
the family members were fighting within themselves.
no, my lordship. Here it is been clearly mentioned that she would mostly end up quarreling with her family members. The same act of Sarah was so evident that the neighbor had to complain about this nuisance to police. 10th line of the fact sheet, first page, my lord.
Time up.
Can I speaker to?
Yeah. Take another minute.
My lord, I want to draw your attention to page number 3, where it is said that from line from line 5, upon the investigation, Sarah and Aras were arrested. Recovery of murder weapon, blood-stained clothes, 10 empty sip tablets, which the all ingredients which were found found from Sarah's possession, as it is clear that they were the one who committed this murder, and this is the sufficient evidence for this to commit the murder, my lord.
All right.
Can you tell me one question, like under the exceptions of 300 in IPC, under which one it fits? Your case comes under?
So the exceptions will be dealt by the respondent side. I am from the appellant side.
Okay. Fine. I'm just asking you. Are you aware about it?
Yes, my lord, I am aware about it. But here the murder has been committed by them, so there is no question of any exceptions on this case.
Okay, fine.
With the permission of the bench, I will interrupt. His time is up. You can proceed with witness prosecution now.
My lordship, can I just end up with my prayers?
No, you can. You have witness prosecution right now.
Okay, my lord. Okay. So, my lord, I want to call up Lala Khan for the chief examination.
Yeah, please proceed.
Lala Khan.
Wait a minute. Just 30 seconds, okay? You can go ahead.
Tell your name to the honorable bench.
Lala Khan.
What happened on the night? What did you see?
It was normal night actually. After having my dinner, I went out for a walk. And while walking, I heard some noise coming from my neighborhood, but I ignored that because I think that was a normal family argument going on.
So what was the reason you entered the house?
While returning back to my home, I heard that noise again, but that was screaming. So I felt something was wrong. So I went to see that, what's happening. So
what did you see? What did you see inside?
Yeah. As I reached, what I see is Sarah's father and mother was lying on the floor with slaughtered neck. They both were dead. And from the adjacent room, 3 more dead bodies were discovered.
Did you see Sarah in the house?
No.
She was not present.
You can't lead the witness.
No, she was not.
Sorry, ma'am. I would like to call Mr. Rajesh Lugade for the chief examination.
So all that this witness has to say is that he saw the dead bodies. That's all.
My lord, here the Sarah was not in the, as he stated that Sarah was not in the house. So after committing murder, she went somewhere.
He has not stated anything. You have put words in his mouth. Anyways, let's see what this witness has to say.
Tell your name to the court.
My name is Rajesh Lugade.
What is your occupation?
I'm a pharmacist.
Pharmacist. So what happened that day? What do you know about the case?
So about the case specifically, I don't know much about the case because I'm a normal businessman. I own a medical store. People come to my store, they purchase medicines, and they go. I don't keep a very great track record of who comes to my store and who doesn't come to my store.
Yes, prosecution.
So who was the for as stated in the fact sheet? It is mentioned by
you cannot lead the witness. You cannot lead. Prosecution is not supposed to ask any leading questions.
My lordship, here it is mentioned that
No,
Mr. Rajesh Lugade has...
whatever is mentioned in the statement is a different issue. What is deposing in the court is a different issue. You can't confront directly with 161 statement.
My lord, here
you can just
Mr.
ask the
Rajesh...
witness. Yes, witness, what you have to say about this? Whether you are called in the police station to record your statement.
No, I was not called to the police station to record any statement.
Okay.
So the
anything you want to depose about the case?
My lordship, here it is mentioned that he has given the statements to the police.
See, your witness has denied in the witness box that 161 cannot be looked into, mister.
Your witness itself is becoming a hostile.
You can declare him hostile and proceed. Under which provision
now
you can declare him hostile? Yes, prosecution.
My lordship, can I call my next witness? Counsel pleads ignorance.
So you are dropping this witness?
Yes, my lordship. Mr. Bilal Ahmed. Tell your name to the honorable bench.
My name is Bilal Ahmed.
What is your occupation?
I have a pawn shop in the locality.
So on that very day, what did you heard?
How you are presuming that he knows that date?
Hello.
On 15th April 2020, what did you hear?
I was just making a pan for the block head, Mr. Bhanu Pratap Singh, and we were just talking. And the group of Ara's friends were gathered a few meters away from my pawn shop, and someone from that group was telling to his friends that Salim purchased the sleeping pills. That's we overheard that.
My lordship, I would like to just note it down because here the planning of the murder has been disclosed, and the Salim who was the one who purchased the sleeping pills for Araz.
Prosecution, you are stretching your imagination. All that this witness has to depose is that he overheard a conversation wherein one Mr. X said that he purchased a sleeping pill. That's all. He has not deposed anything about murder, and you are stretching your imagination. He doesn't know anything about a murder.
My lord, here in the fact sheet. My lord,
please
here in the fact sheet.
Please don't refer to your fact sheets because the witness is in the witness box, and you will have to extract your case from the witness. You can't rely on the fact sheets. I will believe whatever is deposed in presence of the court, not in the presence of police.
What were the statements given by you to the police?
You can't ask this question. Anyways, witness, what do you have to say? Whether you were
5
called in the police
minutes left.
station?
Sorry, can you repeat it?
Did you inform police anything?
No, actually.
Yes, prosecution.
Was called on a crime scene to report.
Your witness is saying he has not informed anything to the police.
Okay, my lordship, I want my 5 minutes for cross-examination, so I'll do the cross-examination.
Who cross-examination by whom?
By the
You are going to
prosecution.
conduct. So you are declaring
Your
that witness hostile?
prosecution, you yourself is a prosecution.
Yes. After the respondent side, I'll do the cross-examination.
No. That is not a provision. To cross-examine this witness, you will have to declare him hostile. Are you declaring him hostile?
No, my lord.
Then you can't cross. You cannot conduct cross-examination without declaring him hostile. You will have to conduct the cross-examination with the permission of the court only after you declare the witness as a hostile witness. Are you aware of the law with regard to hostile witness? Yes, prosecution.
No, my lordship.
All right.
My lordship, prosecution wants to conclude with prayers.
Yeah, please.
In light of the issues raised, argument in advance, and authority cried, may the honorable court be plead
मीटिंग मध्ये जरा दुसऱ्या फोन वरती कर ना. बोल ना, मी बोलतोय मीटिंग मध्ये इंद्रपाल सरांना.
May it plead to this honorable court hold direct and declare that it is prayed before that honorable court that this honorable session court that the accused is liable under section 302 read with 34 shall be punished with the mentioned punishment of the offense committed by the accused. The evidences presented before the court are sufficient to held.
Yes, prosecution. What are those evidences you are relying upon? Out of 3 witnesses, 2 witnesses are hostile. They have not stated anything. So there is nothing. Your witnesses has not supported your case. How you are making a statement that evidence is produced before the court? There is no evidence before the court. What do you have to say about it?
My lordship, here in the evidences here.
What do you mean by evidence?
Evidence, my lordship, murder weapon is also considered to be a evidence, and it is found with Sarah. So, according to that, she is the one who is committing the murder.
As per your fact sheet itself, that was found in the pound.
Found possession of Sarah, sir.
Check your.
It is clearly mentioned. It is clearly mentioned in the fact sheet, my lord.
All right. If you are right, so.
My lordship, 9th line of the third page, possession of Sarah, the last words of the fact sheet. Thank you, my lord.
What about your evidence? What about the witnesses who have not supported your case? What do you have to say about it?
My lord, according to the statement given to the police, here the witnesses.
Tell me the police record statement under which section?
Examination of witnesses.
Yes, my lord. Just a minute.
Read 161, 162. Now tell me whether those statements before the police are admissible.
No, my lord. No, my lord. For that, examination should be conducted, and here.
End of the story. Anyways, we'll consider your argument.
Thank you, my lordship. Much obliged.
Time up.
I would like VM13 to continue with their submissions with the permission of the bench.
Yeah, please.
Am I audible?
Yes, counsel, you are audible.
The council seeks permission to address the bench collectively as your lordship. May it please the much obliged. May it please the court, my team code is VM13, the counsel for defendant in the present case of the state of Assam versus Sara and Araz. The counsel will be dealing with issue number 1 and 2, and my co-counsel will be dealing with issue number 3. Before proceeding with my contentions, I would like to bring it to the notice of this honorable court that no charge sheet is on record in the present matter. Although section 173 of CRPC clearly states that on completion of investigation, the police officer is required to forward it to a magistrate empowered to take cognizance of the offence. Your lordships, I will continue with issue number 3, in which I am contending that the accused are not guilty of the offences under murder of the offences.
You are saying that charge sheet is not filed?
Your lordship, even if the charge sheet is filed, there is no record in the present matter.
See, counsel, you are before this honorable court.
Your lordship, we
Pending
are
your
aware
case
that
only
this
after the charge sheet is filed before this court.
Yes, your lordship, we are aware about that, but we have not been submitted any copy of the charge sheet.
Not submitted?
We have not been given any copy of the charge sheet. Your lordship, may I proceed with the contention?
So, from where you are getting all these facts, if you are not...
Your lordship, in any of the exhibits, the charge sheet has not been filed. Only a report, only a copy of FIR is being given.
All right.
The counsel contends that the accused are not guilty of the offences charged under section 302 read with section 34, and whether the accused have committed the actus reus must be put into question since no direct evidence is available. The defense counsel humbly pleads to the honorable court that the present case be dismissed due to lack of evidence and improper investigation on the part of the prosecution. Your lordship, Blackstone's ratio clearly states that let 10 guilty persons escape, then one innocent suffers. Thus, it is well established that an innocent person must not be punished for a crime that he did not commit. If your lordship could refer to page 10, para 3 of the memorial, in the case of Sadaq Hussain versus the state of NCT of Delhi, the Honorable High Court of Delhi observed that mere recovery of the weapon at the instance of the appellant cannot be the sole premise on which judgment of conviction under section 302 of IPC could be recorded. It is too slender of an evidence to hold him guilty of such an offence. Furthermore, section 34 of the Act clearly states that there must be a common intention, which is lacking in the present case. Sara and Araz had no common intention to commit the cold-blooded murders of her family members. Hypothetically, if Sara would have committed the murders, there is no reason for her to alert the neighbors instead of eloping with Araz or going underground. Without Sara, Araz alone had no purpose to commit the murders of Sara's family members. Therefore, the counsel pleads before this honorable court that both the accused, Sara and Araz, be acquitted against the offences charged on them. If your lordships are satisfied with the arguments, may I proceed with issue number 2?
Let the charge sheet be filed in the court.
Yes.
As you said that you will have to apply for that then, and
Yes,
get the charge sheet and then proceed.
Yes,
See, counsel, you are mixing two issues. 173.8 and 173.
Yes, your lordship.
The filing of the charge sheet, you are praying for a further investigation is a different issue altogether.
Yes, your lordship. We are aware of that. We just wanted to
come with the contention that you want a further investigation. You admit the situation that the charge sheet is filed, but however, we are not satisfied with the report.
Yes, your lordship, we are aware about that. We are just stating that the charge sheet has not been submitted to us since the case is in the trial now. We know that the charge sheet has been filed. Our contention is only that it has not been submitted to us. That's all.
See, my dear,
so without a charge sheet, I'm sorry.
The trial starts once the charge sheet is filed. Before that,
Yes, Your
no
Lordship.
trial takes place, isn't it?
Yes, Your
So at the
Lordship.
time
Yes,
of
Your
the trial, if you don't have a charge sheet copy with you, you can ask court for a
Your
piece of a
Lordship.
charge sheet, and thereafter you can ask them that you need time, extra time for
Yes, Your Lordship.
trial to be started, and thereafter you can proceed, isn't it?
Yes, Your Lordship. May I proceed
is-
with my issue number 2?
Yeah.
Please.
The counsel in issue number 2 contains that the investigation has been unfair and prejudicial. If your lordship could kindly refer to page 12 of the memorial, para 3, in the case of Babubhai versus State of Gujarat, the Supreme Court stated not only the fair trial but fair investigation is also a part of the constitutional right guaranteed under Articles 20 and 21 of the Constitution of India. Therefore, investigation must be fair, transparent, and judicious as it is the minimum requirement of law. The counsel for defendant humbly submits that there has been no submission of the official reports relating to the investigation. No DNA reports of the blood from the bloodstained shirt or axe taken as evidence has been conducted. It is not even has been submitted. It is not even known whether such tests have been conducted or not. Also, the police claim that they have conducted the phone call records of Sara and Araz, but there is no mention of the calls between Sara and Araz and whether they were involved in any kind of planning or preparation needed to hatch an intricate plan for such cold-blooded murders. If your lordship could kindly refer to page 12, last para, wherein in the case of Nirmal Singh versus State of Punjab, the Supreme Court held that an accused is entitled to a fair investigation. Fair investigation and trial are concomitant to preservation of fundamental rights of an accused under Article 21 of the Constitution of India. Your lordship, the mention that Sara had a strained relationship with her family due to arguments between her and her family is a statement from Lala Khan, Sara's neighbor. Your lordship, this statement is under section 161 of CRPC, that is statements made to the police. And as per section 162 of the CRPC, statements taken under 161 do not stand as evidence for trial and in the Honorable Sessions Court. Therefore, there is no reason that Honorable Court must rely on the statements made by Sara Khan since they are statements under 161. Furthermore, your lordship, the death certificate of Sara's brother and sister-in-law under
Why a statement under 161 cannot be looked into?
your lordship, for statements to be taken as evidence, they must be given before the magistrate, and the statements given before the police are not admissible as evidence in the Honorable Court.
Under which provision of law?
Your lordship, under section 162 of CRPC, it is stated that statements under 161 should not be admissible as evidence before the Honorable Court.
What about section 25, 26, 27 of Evidence Act?
Sorry, your lordship.
What about section 25, 26, and 27 of Evidence Act?
Your lordship, I'll get back to you about that.
Fair enough.
Furthermore, your lordship, the death certificate of Sara's brother and sister-in-law under Exhibit C state that the reason for the death is slit throat and asphyxia, but do not mention the presence of any poisonous or sedative substance in their body. Exhibit D2 does not mention the presence of any poisonous or sedative substance in the body except for the presence of a blue smellless liquid, which again is not specified whether it is sedative or not. Your lordship, from the exhibit itself, there is no mention of sedatives in any of the deceased body, and thus the prosecution's theory that Sara had sedated her family members stands disproven. Your lordship, the counsel pleads before this honorable court that the investigation be discarded on the grounds of it being prejudiced, unfair, and unreasonable. I would like to ask my co-counsel to deal with issue number 3.
Can an investigation report be discarded?
Pardon, your lordship?
Can an investigation report filed in the court of the law be discarded?
Your lordship, if it is proved that the investigation reports are unfair or have been
can it be done?
Yes, your lordship, with the
under which provision of law?
Your lordship, I'll get back to you about both the questions that you asked.
All right, many issues.
Okay. Anyways, speaker number 1. Now, your issue was this investigation was not fair and reasonable. At this juncture, you cannot complain of this unless because the investigation is still on. Charge sheet is not filed yet.
According to you.
So this
no, your
issue,
lordship, I'm not saying that the charge sheet has not been filed.
Yeah,
I'm
so
just
this
saying
issue
that
number-
a copy has not been submitted.
copy is not submitted. You can ask to the court.
Yes, Your
immediately.
Lordship. That is why I was asking before beginning with
So
my
are you sure now that the
contentions,
copy is filed and you need a copy
yes,
of it?
yes, Your Lordship. We just
Okay.
need a
Thereafter,
copy.
the issue will be dealt with.
Yes, Your Lordship.
Yeah. Okay.
You have also third issue to get back.
Yes,
Under,
Your Lordship.
tell me the section under which the prosecution is compelled to supply the copy to the accused.
Your Lordship, so I'll get back to
Okay.
you. During the cross-examination, I'll ask
All
you
right.
answer all the 3 questions.
Okay. Okay.
All right.
With the permission of this honorable court, the counsel would like to start with the oral arguments.
Yeah, go ahead.
Much obliged. Your Lordship, this is counsel number 2 appearing on behalf of the defendants in the case of State of Asta versus Sara and Araz, and would be dealing with issue number 3. Your Lordship's issue number 3 deals with the question that whether the circumstantial evidence is sufficient to convict the accused in the present case. The counsel would like to elaborate and explain this issue in 2 folds. The first fold of my argument would deal with the concept of proof beyond reasonable doubt. Maximum criminal justice systems of the world follow the principle that the guilt of an accused should be proved beyond reasonable doubt. Indian criminal justice system also works on the same lines, as it is for the prosecution to prove beyond reasonable doubt that the accused has committed an offense with requisite mens rea. In criminal cases, the guilt should be proved beyond any reasonable doubt that a reasonable man with ordinary prudence can have. There should be no doubt whether the accused is guilty or not. If there is slightest doubt, no matter how small it is, the benefit will go to the accused. In the Indian legal systems, the provision regarding the burden of proof and how it is to be discharged are laid down in Chapter 7 of the Indian Evidence Act of 1872. The rule is that whoever alleges a fact must prove it. In a criminal trial, it is the prosecution who alleges that the accused has committed the offense with requisite mens rea, and so the burden of proof lies upon the prosecution to prove the same. If your lordships could please refer to page number 15 of the memorial, first paragraph, where the Supreme Court, in the case of Gurbachan Singh versus Satpal Singh and others, had held that criminal charges must be brought home and proved beyond all reasonable doubt. While civil cases may be proved by mere preponderance of evidence, in criminal cases, the prosecution must prove the charge beyond reasonable doubt. There must not be any reasonable doubt about the guilt of the accused in respect of the particular offense charged. The courts must strictly be satisfied that no innocent person, innocent in the sense of not being guilty of the offense of which he is charged with, is convicted, even at the risk of letting some guilty persons. Your lordships, this brings me to the second fold of my argument. The second fold of my argument deals with the question of circumstantial evidence which is presented in this case, and would like to explain to the court as to how it is insufficient to convict the accused. As we all know, circumstantial evidence is referred to as indirect evidence. Direct evidence is given more preference than circumstantial evidence, as it
Not yet.
Now, your lordships, am I audible?
Yes, you are audible.
Much obliged. Your lordships, as we all know, that circumstantial evidence is referred to as indirect evidence. Direct evidence is given more preference than circumstantial evidence, as it does not require any type of inference, and it is a direct proof of an illegal act committed. But in the case of serious offenses such as murder, for which the punishment is death penalty, conclusion cannot be drawn solely on the basis of circumstantial evidence, as it requires proof beyond reasonable doubt. If your lordships could please refer to page number 16 of the memorial, first paragraph, where the Supreme Court in the case of state of Madhya Pradesh versus Govind Singh and others had held that reasonable doubt must grow out of the evidence in the case or from the lack of it, as opposed to mere vague apprehensions. If we compare this judgment with the present scenario, the chain of events is quite unsatisfactory and based on probability and mere speculation. The recoveries made by the investigating officer are not backed by evidence and therefore fail to prove the commission of the offense. Furthermore, the investigating team had reached the crime scene 5 hours after it was actually reported. Also, the facts stated by the investigating officer cannot wholly be taken into consideration, as the apex court in the case of Haricharan Kurmi versus state of Bihar had stated that the confession of an accused person is the best evidence if it is voluntary. To make this happen,
So from where you got all this information, because charge sheet is not available with you?
Yes, Your Lordship, but the fact sheet clearly states that the investigating team had reached the crime scene 5 hours later.
No, what my learned senior brother is trying to tell, your first counsel submitted that you have not been supplied with the charge sheet copy.
Correct.
And you are arguing in
all
detail.
that incidents, all that incidents you're talking about, which was supposed to be there in the charge sheet.
Yes, Your Lordships. We are merely stating that the charge sheet is not given to us in the exhibits file, but it might be filed, Your Lordships.
Right. First, you need to be sure about everything.
We take your content.
Address on any issues.
Yes, Your Lordships, indeed.
And as far as the circumstantial evidence, the chain you are talking about, once the Sahara is found at the place by Lala Khan as well as the police, when they arrived, she is not disputing her presence. Secondly, the recovery of the knife at her instance, in her possession, statement. So to me, the chain of events and chain of circumstance is complete.
Indeed, Your Lordships. It is merely a mere suspicion that all of this is there with Sarah. Now, the fact that if Sarah
that is not a suspicion, that is a fact sheet.
Yes, Your Lordship. So if we consider the fact that Sarah had the murder weapon with her, does not prove to the fact that she has murdered, right?
So you mean to say, unless and until there is an eyewitness to any incident, nobody in this world can be convicted?
They can be convicted, Your Lordships, but the fact that this is a murder case, and in this we merely can't depend upon the circumstantial evidence that is presented by the prosecution, Your Lordships.
For your kind information, half of the cases in the murder trial are on circumstantial evidence.
Evidences only.
But that, yes, indeed, Your Lordships, but that must be proved beyond reasonable doubt. Here, there is suspicion on the, if Sarah had the murder weapon, where is the DNA report or the fingerprints report, which would prove to the fact that she has committed the offense?
The motive is there, correct? The motive.
No, Your Lordships. Mere the fact that Sarah was present in the house.
Parik ji, I think we have lost speaker number 2. Our internet connection is not proper.
Am I audible now, Your Lordship?
Now you're audible again.
Yes.
Yes.
Am I audible to you, counsel?
Yes, Your Lordships, you're audible.
Now the issue is, when the case is based on the circumstantial evidence, then at the main thing to deal with is the motive. When there is a direct evidence, then you don't need to prove the motive. But in the case of circumstantial evidence, motive is the essential criteria. Now, as far as this case is concerned, the motive does exist, correct? Once the motive does exist, the presence is not disputed, the possession is also not disputed by your client, that is Sarah. She has not disputed that it is not found in my possession. Had it been your case that the murder weapon is not found in my possession, I can buy your argument to a certain extent. But since you are not disputed, this argument is not available to you.
Your Lordships, I agree to the fact that you are saying that murder weapon was found with Sarah, but the fact sheet clearly states that Sarah and Araz had to convince their family members about the love affair that they had, and this clearly concludes to the fact that they did not have the motive to murder anyone.
Okay, counsel number 2, in your issue number 3, you have contended that the concept of proof beyond reasonable doubt, right?
Yes, Your
Can you
Lordship.
tell me the 2 systems which are present in the country or throughout the world? Which are the 2 criminal systems which are present, which says that the concept of proof beyond reasonable doubt is there? In one of the systems, you will find this kind of a concept. There are 2 systems. Do you know about the 2 systems at least?
No, Your Lordships, the council is not well aware of the fact.
Okay, there are 2 systems called as inquisitorial and accusatorial. So which is this system which says that concept of proof beyond reasonable doubt comes in? There are 2 systems, inquisitorial and accusatorial. So which one is the system do you feel that which is applicable in India?
Your Lordships, the council is only aware about the fact that the burden of proof which the council was talking about.
Council, there is a specific query put by the brother judge.
So I said there are two kind of a system. One is inquisitorial and one is accusatorial system. So under which concept this concept of proof beyond reasonable doubt comes? Very simple question it is.
Your Lordships, the council will get back to you in a while on this particular question, Your Lordships.
The term itself says accusatorial system.
Yes.
Isn't it? In accusatorial system, till the time the person is not held guilty, he is found to be innocent.
Innocent, yes.
So hence we say that the concept of proof should be not only on reasonable doubt, but it should be beyond reasonable doubt.
Yes,
okay,
thank
please
you.
Go ahead.
Yes, much obliged, Your Lordships. Also, the well-known rule governing circumstantial evidence is that each and every incriminating circumstance must be clearly established by reliable evidence, and the circumstances proved must form a chain of events from which the only irresistible conclusion about the guilt of the accused can be safely drawn, and no other hypothesis against the guilt is possible. In the present case, as there exists no direct nexus between the circumstances presented and the evidence sought, they are not sufficient to prove the guilt of both the accused members. If Your Lordships are satisfied, the council would like to move ahead with the prayer.
Council, now as far as whatever argument you have advanced about all this beyond reasonable doubt and all,
2 minutes left.
Can you connect this with your case? See, you will have to connect your argument along with the case. You will have to take example of the witness and the evidence which is there in your case, and then argue that submissions.
Yes.
We are arguing about the submission. There are n number of judgment which are passed by the number of honorable benches every day.
Indeed, Your Lordships.
Will not come to your rescue.
Indeed, Your Lordships, and we'll try to prove that in our cross-examination, Your Lordships.
Fair enough, and I would like to ask one more question. You relied on the judgment of Delhi High Court. Now tell me whether the judgment of the Delhi High Court is binding on us.
Your Lordships, every case that has been submitted in the memorial is a Supreme Court judgment and not a Delhi High Court.
1 minute left.
The very first case you relied was a Delhi High Court judgment.
Your Lordship,
even if
intervene.
Anyways,
yes,
you can conclude your argument.
Much obliged. I'll just take 10 more seconds to go with my prayer, and that's all. With Your Lordship's permission, much obliged. In the lights of the issues raised, arguments advanced, and authorities cited above, the defendants humbly pray before the Honorable Sessions Court of Asta, firstly, to acquit the accused of offences punishable under Section 302, read with Section 34 of the IPC. Secondly, direct the prosecutor for re-investigation and pass any other order, direction, or relief that it may deem fit in the best interest of justice, fairness, equity, and good conscience. For this act of kindness, the defendant shall be duty-bound and forever pray. Much obliged, Your Lordships.
So prayer number 2, the court will think about, because after the charge sheet only, it will be decided whether re-investigation is needed or not. And in the meantime, the council number 1 wanted to speak something.
Yes, Your Lordships.
Can the council number 1 sum up within half a minute?
Yes, Your Lordships. I would like
please.
to get back to you about the questions that you had asked. Your Lordships, first of all, the Delhi High Court judgment is not binding on this honorable court, but we just stated it as a reference which was related to this case. Secondly, Your Lordships, about Section 25 of the Indian Evidence Act,
No, but then this matter is under additional session magistrate, right?
Yes, Your Lordship.
Okay.
ASTA. Therefore, the Delhi High Court judgment is not binding upon this honorable court, but it can still be taken as a reference before judging this case. Your Lordship, regarding Section 25, it is stated that the statement given to the police need not be proved, and Your Lordship, we are not stating statements that are given by Lala Khan are false. We are just stating that they cannot be admissible as evidence before this honorable court. And thirdly, Your Lordship, section 207 of CRPC is the section that states that copies need to be served to the accused.
Without that, the trial cannot proceed, right?
Yes, Your Lordship. Yes, Your Lordship.
So
But
consider
we have
about
been
your
brought
submission.
before. Yes, Your Lordship. But we have been brought before this honorable court, and it is our duty to fight for our accused, for our client. So that is why we went ahead with the contention.
Please.
Okay.
With the permission of the bench, can I interrupt?
Yeah, please.
Please.
This team doesn't want to go ahead with witness prosecution, or are you done with your pleadings?
No, if they have the
We want
prosecution
to do
witnesses,
cross.
Yes,
We want to do the cross examination.
if there is time and if they want to do the cross examination, okay, let's go
We
ahead.
just need 5 minutes. We don't need 10
Considering that the charge sheet is filed, okay?
Okay, sir. Sure. You can call upon the witnesses as you like.
Yes, sure. Your Lordships, with your permission, I would first like to call Mr. Lala Khan, who is the neighbor in the present case.
Please.
Granted.
Much obliged, Your Lordships. Mr. Lala Khan.
10 seconds. 10 seconds.
Mr. Lala Khan, could you please tell the court as to where were the statements given, or did you give your statements to the investigating officer?
No, you are conducting cross-examination, right?
Yes, Your Lordships.
I have
Yes, Mr.
informed the
Lalakan.
police via call.
Your Lordships, the fact that the statements were given in front of the investigating officer could not be held admissible, as it was already stated by my co-counsel that statements given to the investigating officer are not admissible. It would have been admissible if they were given before a magistrate.
Counsel conduct cross-examination presuming that that statement is given before the court, and now you have to carry forward with the cross-examination. Forget about that statement.
Okay. Much obliged, Your Lordships. So, Lala Khan, on the day of the crime, did you saw Araz entering or exiting the crime scene?
I couldn't hear you. Can you repeat?
Yes, on the day of the crime, did you see Araz entering or exiting the crime scene?
He has not stated so in the statement.
Exactly. And Your Lordships,
Why you are inviting trouble?
Your Lordships, the fact that the witness had already stated in the examination in chief that he had seen Sarah. He had went to
Araz. He has not
sorry.
stated
He
anything.
had went to the house on the mere fact that he had heard hues and cries. The fact that he went to the house, according to the fact sheet, which states that he went to the crime scene only because Sarah created the commotion after seeing the dead bodies, Your Lordships.
Exactly, counsel. That is what I'm trying to tell you, that he has not stated that he has seen Araz. Then why you are inviting trouble?
And I don't know who has created that commotion. I don't know.
Your Lordships, the fact sheet clearly states that Sarah had created the commotion. She was crying.
All right, counsel, you can proceed with the cross-examination.
Much obliged. Your Lordships, I would now like to call upon the pharmacist Rajesh Lugade for the cross-examination.
Yeah, permission granted.
Much obliged, Your Lordships. Mr. Rajesh, at what time and date did Araz come to the medical shop on that fateful morning?
I don't recall the time because there are multiple customers who come to my store. So I don't recall at what time he came, and neither the date I recall properly.
So, counsel, you are admitting that Araz visited his shop for buying something?
We are not admitting anything, only the fact that... No, the fact that it is stated in the fact sheet that Araz had only attempted to buy the pills, but he did not buy the pills. And I want to
your
ask
cross-examination to the issue that whether this witness has stated that particular fact on which you are conducting the cross-examination.
Indeed, Your Lordship.
Counsel number 2, as my learned friend said, you are admitting the case. You started admitting the case now.
Am I audible now?
Yes,
Yeah, yeah.
yes.
she is.
Much obliged. So, Mr. Rajesh, did you give the medicines to Mr. Aras?
I did not give him any medicines because he was not
Exactly. This
having.
proves.
Yes,
Yes,
so
indeed.
I'll come to it. So I know Aras because he's a regular customer to my store. So, but on the given day, he was not having any proper prescription. So because of that, I did not give him any medicines.
All right. So, your lordships, on this fact, how can we even consider that Aras and Sara
Counsel,
had
you're
given?
like you're digging for
Your
your
lordships,
own
I'm
case.
only trying to prove
No,
a point
you have
here.
proved in fact that Aras did visited his shop. You also proved the fact that Aras asked for the medicine.
Tried to buy the pills since he didn't had any prescription. He couldn't. So
No,
probably
your
he
In
might
lordships,
fact,
have
it
you
was
proved the
just
case of the
some other medical
prosecution.
shop.
your lordships, this was just a question to ask the pharmacist whether he had given the pills
Now that
and
is a
if he
matter of
had.
record now.
Your lordships, may I continue with the cross-examination?
Yes,
Yeah,
co-counsel number
counsel
1.
one.
Your lordships, may I be permitted to examine the doctors who gave the death certificate reports?
Okay, proceed.
So, your lordships, I would like to call Dr. Shashank first.
Yes. Where is the doctor?
Yeah, medical expert. Yes.
Okay, Dr. Shashank, on whom did you conduct the post-mortem?
I considered the 3 dead bodies named as Vasan, Hina, and Nar.
Okay, so what kind of injuries were there on their bodies?
Their bodies were slit-throated.
Okay, all of them?
Yes.
Okay, your lordships, as the doctor said that all of the bodies.
Counsel, rather, why don't you ask about the doctor that whether the post-mortem report is given by him or not, and things will be admitted.
Your lordships, in the exhibit, his name is mentioned on the report. That is why I did not go ahead with that question.
Okay, fine.
Your lordships, as the doctor stated that all of the 3 bodies had slit throats, but in the report, but in the fact sheet, it is mentioned by the investigating officers that Nal had been throttled and not his an incision was not present on his neck. It has been clearly stated that he had been throttled. So, your lordships, this witness or the report is not credible before the honorable court, since there is no proper mention about the injuries present on the deceased body.
Is it?
Yes, your lordships.
How many diseases you examined?
Your lordship, it is mentioned on page 2, first line, that Nal had been throttled and not killed with an axe.
Page number?
2, first line. Page 2, first line of the fact sheet, it has been mentioned that Sara throttled Nal.
Can you refer to Exhibit D, the medical certificate issued by the doctor?
Yes, your lordships. I would like to.
2 minutes left.
Yes, your lordships, on Exhibit D, cause of death is being given as slit throat and asphyxia. So, and the doctor. Sorry, your lordships.
So medical evidence is there, expert evidence. The documentary evidence will prevail.
Yes, your lordships, but the investigating officer has mentioned that Nal had been throttled to death. So there is discrepancy between the 2 reports.
Now tell me whether the court will look into the documentary evidence which is prevailing in the charge sheet or the state.
Is that there is discrepancy between the investigation and the medical reports that have been submitted. We are not.
Time up.
Discrepancy in the substantive evidence can be looked into, not otherwise.
Yes, your lordship.
Time up.
Your Lordship.
We'll consider your argument since time is already up.
Yes, Your Lordship. Thank you.
Okay, Dr. Shashank, you may leave now. Your deposition is done.
Sir, we will take a 5-minute break and admit the next team.
Okay. Acha, who's the next one?
My lordship, rebuttal for the points.
Do you want to rebut some points?
Yes, my lordship, indeed.
Okay, you can go ahead now with the permission of the bench.
Okay. 2 minutes or 1 minute?
2 minutes. 2 minutes.
2 minutes. Okay.
Okay. As it is mentioned by the defense that the murder weapon was found in the possession of Sarah. Not only the murder weapon, but all the ingredients which were used for murdering were found, and the intent and the motive lies with Sarah and Araz. Only Sarah and Araz. There is no one other than Sarah and Araz who will be beneficial of the crime committed. And as the defense have accepted that the Araz went to the pharmacist for sleeping pills, and as the pharmacists are also confirmed that, and my lordship
given it to Araz, right?
Yes, my lord.
Then how are you relying on that?
But he has made an attempt, as he wanted that on behalf of.
He made an attempt, but where is the proof that he has purchased and he has administered that pills to the disease? There is no proof. So how you can
my lordship
with the crime?
Yes, my lordship, here. As my lordship, here, Salim, who has purchased sleeping pills, who was friend of Araz, it could not be a coincidence that he would have gone on the same day and purchased the same medicine which Araz wanted.
But whether Salim has confessed to the issue that he has given that pills to Araz?
It was heard by Bilal Ahmed and Rajesh Lugade that
is there any evidence to show that Salim in fact bought it for Araz and gave it to Araz? Whether this chain is complete?
As he wanted, and the crime has been committed, it is totally inferred that they have used the same sleeping pills to kill them.
So your case is on presumption, inference, assumptions.
No, my lordship, here. But the chain, if we see the chain properly,
just
all
tell
of
me the chain of
time up.
Passing of these tablets to Araz. Can you complete this chain?
Time up. You're not allowed to speak further.
My lordship,
Okay.
The next team will be VM11 and VM15. Moot propositions have been sent to you.
For rebuttal.
Yeah, this team must also be given the opportunity for rebuttal.
Okay. Yes, Your Lordships. We would just like to say 3 things. First of all, there is no proof of sedation in any of the family members' body as per the doctor's report. Therefore, the fact that the prosecution is trying to establish that they have been sedated with the use of sleeping pills cannot stand. And secondly, Your Lordships, the day on which Salim purchased the sleeping pills has not been mentioned. The date has not been mentioned. It could have been a month prior or 2 months prior or 3 days prior. So that is not been mentioned anywhere. So that what the prosecution is trying to say, that Salim purchased it for his friend, cannot stand. That's all, Your Lord. And thirdly, Your Lordships, the recovery of murder weapon at the instance cannot be the sole proof to declare that Sarah or Araz have committed the murder. That's all, Your Lordships.
All right, counsel.
Sir, as they are done with their proceedings, we will proceed to the next case. The next 2 teams are VM11 and VLM15. The both of the moot propositions have been sent to you. There will be a 5-minute break between the propositions.
All right.
Okay, you can read the proposition.
Can we take 10 minutes break? You said.
Yeah, no problem, sir.
Thank you.
Okay, I guess we have a 5 minutes break now here.
No, sir, took a 10-minute break, sir.
Okay, fine. You send me the copies because I haven't received it till now on my email. You send me on WhatsApp only again.
Okay, so I will do that. I will confirm with ma'am. Okay, thank you.
Yeah, because we need to take printout of all this.
Okay. I will do the same, sir.
Fine.
आता हूँ।
अरे भाई क्या क्या लाते हो
वही बोल रहा टाइट तो हो ही जाता है। हेलो मैम, हाउ आर यू? हाँ, मैं तो अच्छा दिखता ही हूँ। हम लोग दोनों अच्छे दिखते ही हैं मैम। ये आप आज देखे आपने।
Good down.
So we will be starting the proceeding in 2 to 3 minutes. We will be starting with the proceedings in 2 to 3 minutes. Are the judges present? With the permission of the bench, may I start with the proceedings?
Yes, yes.
Yes, you can proceed.
I would like VM11 to start with the prosecution. Appellant. You're not audible to everybody. Please increase your volume. Team VM11, please increase your volume.
Now am I audible?
Yes, you are audible.
Lordship, may I proceed with the please?
Yes, proceed.
Right. I'm public prosecutor, Master Swapnil Padekar. That the FIR number 184/17 registered to Section 302, Section 34 of Indian Penal Code within the Udhamnagar Police Station, which falls under the jurisdiction of our Honorable Court. So, our Honorable Court has complete jurisdiction to try the matter. Hence, the matter is before this Honorable Court.
Directly come to the point.
May I proceed with the fact of the case?
Yes, yes. Why are you not in proper attire?
Sorry, Lordship.
Why are you not in a proper attire?
Proper?
He's seeking exemption of summer.
Dress code.
No, Lordship. As per the guidelines, rules and guidelines provided by HVPS Law College, the white shirt and black pant is the dress code. So, obliged.
All right.
Obliged. May I proceed?
Yeah, please.
Yes, Lordship. The fact of the case is that the accused number 1 and 2, simultaneously accused number 1 is Aras and accused number 2 is Sarah. Both were involved in a romantic relationship with each other, which was totally opposed and resisted by their family members of accused number 2. The main reason of resistance to their relation by family member was the difference between financial and societal status of the accused number 1 and 2. As accused number 1 belongs to Sunni community, which is also considered as a lower community in the state of Assam. Both accused have made several attempts and several tries to force a family member of the accused number 2 to accept their relationship, but it resulted into the failureless of their attempts. So, due to the resistance made by family member of accused number 2, it frequently leads to the fights and dispute among the accused number 2 and a family member, to such extent that it resulted into nuisance and disturbance to the neighbor. For that reason, some neighbors also had filed the NCR report in Udhamnagar police station. Finally, both made a devious plan of murdering entire family member of accused number 2 to remove all the opposition to their relationship. Accused number 2, being well educated, also aimed to become one and only survivor, hired to succeed the wealth of her family property and planned to murder all family members of accused number 2 with the help of accused number 1. So, on the night of 14th April 2020, accused number 2 sedated all her family members by mixing a sleeping pill in the cup of tea, which she served to all the family members except her nephew now. After that, on intervening night of 14th April to 15th April, accused number 1 entered to the house and accused number 2 pulled each of her family members' head by the hair, while the accused number 1 chopped them off, but one by one. On 15th April morning, Lala Khan, the informant, entered the house and found a lifeless dead bodies of the family members of accused number 2. While he also found Razia, which is alive but in semi-conscious state with an injury on it. He suddenly took her to the local government hospital and informed to the police officer of Udhamnagar police station. So, as per this, FIR number 184/17 was registered as per the 154 of Code of Criminal Procedure at Udhamnagar police station at Badoy on 15th April 2020 at 10 a.m. through API Vilas Deshmukh, annexed hereby Exhibit A. Then the Rajia was examined by Dr. Karnik, who is a doctor of BGM hospital, and submitted the medical. IO also recovered the blood stain, pillows, mattresses, quilt, and rope. Nokia phone, empty strip of 10 tablets, blood stain, cloth, and mobile SIM card of accused number 1 was recovered from accused number 2. Follow-up record between both the accused obtained, and based on the strong suspicion of guilt that the accused number 2 is get arrested, and upon further investigation and medical examination of accused number 2, it was found that she was pregnant for 2 months. While in
5 minutes left.
Reveal the story that the accused number 1 entered the house of accused number 2 with a knife and killed all the family members. Based upon the statement of accused number 1, was arrested by the police, and upon interrogation, he also confessed, and he also stated that he had reached the house and with knife and murdered all family members, but he only the request of the accused number 1 is there. So, based upon this fact, the trial is before this honorable court for the interest of the justice.
See, what was the request of accused number 1 you said? You said there is a request from accused number 1.
No, sir, no request. He had reached.
Achha, he has reached.
He has reached on the request of accused number 2.
Okay.
That submits that accused number 1 also has common intention with accused number 2.
Okay, proceed ahead.
May I proceed with the chief?
Yes.
Yeah, please.
Yes. I would like to invite Mr. Lala Khan, the complainant, for brief examination.
Okay.
Yeah, please proceed.
Mr. Lala Khan.
Ten seconds, please wait. We are organizing.
Hello. Hello. Hello.
Okay.
Mr. Lala Khan, where do you live?
In Udhamnagar.
Okay. So, since from how many years do you know accused number 1, accused number 2, and her family?
I only know Sarah's family since the last 2-3 years.
Okay. So, what do you know about the relationship between accused number 1 and 2?
I have only heard about their relationship.
Being a faithful labor, do you aware about that the situation of family members were against of that relationship between accused number 1 and 2?
Yeah.
Tell us what happens on 15th April when you entered the house of accused number 2.
Counsel, you are presuming that he has entered. He has not stated anything. Allow him to answer. Allow him to state something. You are presuming many things, that they had relationship. Then that is your case. Let the witness depose. He is blank.
It was not on 15th April. It was on 14th April.
Okay.
It was on 14th April.
Yeah.
Sorry, Lordship, I was disconnected.
Hello.
Mr. Lalakar, can you repeat?
It was on 14th April.
What was the condition of Razia when you took her to the local government hospital?
She was
Prosecution, you are leading
unconscious.
the witness. You
Obliged,
cannot lead the witness. What was the condition? What was it? Has he stated that he saw Razia? Let him depose. He has not stated that he entered, he saw Razia, nothing. This is
No,
not the way to extract.
Sorry, I was disconnected, so I was unable to hear that.
So you presume everything?
No, sorry, Lordship. Yes, Mr. Lalakar, when you entered the house of accused number 2.
Did he enter the house?
Huh?
He has not stated that he has entered the house.
Did you enter the house of accused number 2 on 15th April?
Yes.
Okay.
See, Mr. Counsel, you are supposed to ask what happened on 15, what you have to say about 15. That's all. You cannot lead the witness. You are not conducting the cross-examination. The rule of examination, chief and cross are different.
Yes, Lordship. I already asked him that tell us about what happened on 15th April.
It was on 14th April.
That is your facts.
After having
Anyways,
dinner.
witness, you proceed.
After
Yes,
having
Mr.
dinner.
Lalakan, what you have to say?
Hello.
Yes, Mr. Lalakan, am I audible?
Yes. After having
Tell
my
us
dinner.
what you have to say about that 14th incident.
After having my dinner, I was walking on the street. So I heard some voice coming over from the neighborhood. So I felt something was wrong there. So I went to see what's happening there. So as I reached there, what I'm seeing is Sarah's father and mother were slaughtered and they were both dead. And in the adjacent room in their house, 3 more dead bodies were discovered by me. And one of them was Sarah's brother, Sarah's sister-in-law, and their child. And Razia was also discovered by me. She was unconscious and her neck was slit slightly and she was bleeding.
Okay.
So I took her to the hospital.
Okay, you took her to government hospital. Okay, Lordship. May I proceed with for the witness?
Yeah.
I can't say by my.
He's done with his deposition.
Okay, Lordship. Done. May I proceed with next witness?
Yes, please proceed.
Yes. Next witness is Dr. Taksh.
Dr. Taksh.
Yes.
Yes, prosecution, proceed.
Yes. What is your qualification and where you work?
5 minutes left.
Okay, go ahead in the meantime.
Yeah. Please ask again.
What is your qualification and where you work?
I am a master surgeon in government hospital at Udhamnagar, and wherever I went.
Sorry?
Where was I when?
At what time and on which date deceased come to the hospital?
She came on 15. I don't remember the exact time.
Can you tell me the name of the person to whom you have done postmortem?
I did it on Mikesh and Ashka.
Okay. What is the exact time of death of deceased person as per postmortem done by you?
The approximate time was between 11 to 11:30 p.m.
Okay. What was the reason of death?
The reason of death was slit throat and asphyxia.
Can you tell which weapon has been used to kill them?
Sorry, counsel.
Sorry?
Can you tell which kind of weapon is used to kill the all family members or the postmortem you have done?
All family members. She has not examined all family members.
No. I just say that the person, the deceased person to whom you have done the postmortem, which kind of weapon has been used to kill them?
It was obviously a sharp weapon. The incision was deep, but I cannot claim any such weapon.
Sharp weapon, any examples?
Maybe a knife.
Sorry, am I audible?
To confront, you will have to show.
Currently, we don't have that, but being a medical officer,
so being a medical officer, she has already stated that it was a sharp weapon. That's all.
Okay, Lord. Okay. Next, I would like to Chief Dr. Shashank. Dr. Shashank.
Hello.
2 minutes left.
What is your qualification and where do you work?
I'm mastering surgeon in Uddamnagar Government Hospital.
Okay. On which date and time disease come to hospital?
Disease never come. Disease are brought.
Oh, sorry, Lord.
I don't know the approximate time, but on 15th April.
Can you tell the name of the deceased to whom you have done postmortem?
Yes, Vasan, Hina, and Nal.
Okay. What was the reason of death?
Reason of death was asphyxia and slit of throat.
Okay. Thank you. Doctor, may I proceed with witness Bilal Ahmed?
Yes, please.
1 minute left.
Bilal Ahmed?
Hello. Yes.
What is your profession?
I have a pan bidi shop in a locality.
What do you heard on 15th April?
You are presuming that he has heard anything. You can't lead witness. Again and again, I am warning you.
Oblige, boss. Oblige. Do you heard anything? The conversation
again
between accused and
no, Mr. Counsel.
Okay. What do you observe on the fateful day when the incident was happened?
The blockhead, Mr. Bhanu Pratap Singh ji, came to my shop and we were just talking we were just talking and the Aras friends. Hello.
Okay, go ahead.
Time up.
So,
the last witness, Rajesh Lubde.
Time is over, Mr.
Hello.
Speaker number 1, you have to be within the limits of your time. You have already exceeded the time.
So you have been allotted a time for pleading and a time for witness prosecution. So you have exceeded the limit for witness prosecution, I think so. So you cannot prosecute any
So
more
can we start with the defense counsel?
witnesses.
Yes, Lordship. Yes, Lordship. Oblige.
Your Honor, I'm the speaker number one for the accused number 1 and 2, the defense counsel. If the court permits me, I would like to address this bench as your lordship. Your lordship.
Yeah,
Okay.
please.
Yeah. If the court permits me, I would like to reiterate the facts correctly, as my learned prosecutor friend did not state them as to what had happened.
No, but then
Your
we are
Honor.
aware of the facts now, by now.
Oh, okay, Your Lordship. I will start with the arguments then.
You can
Your
directly
Lordship.
come to the point.
Yes, Your Lordship. Your Lordship, the disclosure statement of accused number 2, which is Araz and not Sara. Araz, the statements made by Araz were in the presence of the investigating officer. Your Honor, Your Lordship, Section 54, subsection 2 of the CRPC states that when any person is arrested, he shall be examined by a medical officer, and a copy of such report shall be given to the arrested person. In the light of absence of any medical examination report of accused number 2, it is submitted that the same should have been presented in the court of law to prove that the statement was made voluntarily and not under any threat of physical harm. Your Lordship, in the case of the state of Uttar Pradesh versus Deoman Upadhyay, the court had held that by Section 25, there is an absolute ban against proof at the trial of a person accused of any offense of a confession made to a police officer. The ban, which is partial under Section 24 and complete under Section 25, applies equally whether or not the person against whom the evidence is sought to be led in a criminal trial was at the time of making the confession in custody. Your Lordship, the recovery affected under Section 27 would be relevant and important only if recovered items were used in the commission of the offense. In the case of Sangli versus the state of Tamil Nadu, the court had held
The weapon which was recovered was used in the commission of crime only. It was recovered at the instance of accused number 1.
Your Honor, the weapon which was recovered was at the instance of accused number 2's arrest and not accused number 1's Sara, Your Lordship.
Are you sure about it? Fact?
Very sure, Your Lordship. It was at the instance of Araz and not Sara.
Okay.
Your Lordship, in the case of Sangli versus the state of Tamil Nadu, the court had held that it is a settled position of law. A suspicion, however strong, cannot be a substitute of proof. In a case resting on circumstantial evidence, the chain of circumstance must be so complete that they lead to only one conclusion, that is the guilt of the accused. It is not safe to record a finding of guilt of the accused, and the accused is entitled to get the benefit of doubt. Your Lordship, the base to prove the guilt of accused number 2 is that he works in a wood sawing unit and he is well trained to handle an axe. Your Honor, the axe found in the position of accused number 2 was never sent for a synthetic blood analysis, which could prove that were there any stains of blood on the axe or not, and if they were they of the victim or his own. Your Lordship, I would further submit that the prosecution has not put forward any evidence to show that the blood found on accused number 2's shirt was of the victim's, as the shirt was not sent for forensic report. The blood could have been his own, owing to the nature of his employment. Cuts and bruises are a common sight. Your Lordship, I would also like submit that the axe, by the absence of the report of the axe, there is no substantial proof that the axe was used in the commission of the offense. In the case of Mustaqim versus the state of Rajasthan, it was held that the discovery of material object at the disclosure of the accused does not automatically lead to the conclusion that the offense was committed by the accused. The burden lies on the prosecution to establish a close link between the discovery of the material object and its use in the commission of the offense. What is admissible under Section 27 of the Indian Evidence Act is the information leading to the discovery and not any opinion formed on it by the prosecution. It is therefore the disclosure statement of accused number 20, Section 27 of the Indian Evidence Act is admissible. Your Honor, in the testimony of Your Honor, the testimony of Salim was not recorded and was not called on record to testify on the question of sleeping pills, Your Honor. Salim is the only person who could have linked accused number 2 or accused number 1 to the sleeping pills, which sleeping pills, since the prosecution is relying entirely on the theory of sleeping pills were being used in the offense committed. Therefore, there is a prejudice to the accused to prove their innocence. Your Lordship,
Prosecution is not solely relying on Salim. Prosecution is relying on the fact that Sahara was found at the scene of offense. At the same time, all the material, the incriminating article were seized at the instance of Sahara and hers. Circumstantial evidence. They are not relying on Salim's evidence.
Your Lordship, we will be addressing this issue on our further arguments too.
On the further arguments, Your Lordship. Your Lordship, I would like to state the last case upon my arguments, upon my part of the arguments, that in the case of Dina Bandhu versus the state of Odisha, the court had held that if a material witness has been deliberately and unfairly held back in a serious
5 minutes left
on the trial itself and its validity of the conviction resulting from it may be open to challenge. Your Lordship, I'll be handing over the arguments to my learned co-counsel.
Yeah,
Your Lordship, I will begin by stating that the investigation done by the police and the forensic team is not complete in its nature, as crucial evidence such as strips of tablets, axe, and blood-stained shirts have not been sent for further detailed investigation as to their contents and nature, in whether they relate to the accused or not. The evidence brought forth by the police is circumstantial and hearsay. In addition, there are also lapses in the investigation. There is failure to establish guilt beyond reasonable doubt. The investigation team reached 5 hours after the incident was reported. This delay of 5 hours shows that the crime scene could have been disturbed by the incoming flock of neighbors or other curious bystanders. The investigation team also did not send the evidence for further forensic report. And in view of bloodstained shirts, it is submitted to the court that when such an unfortunate incident happens, it is very human for a person to go on check on their family members who are lying on the floor dead and in pools of blood. And as such, the blood can stain the shirts and the clothes of the accused in this particular case. With regards to testimonies of Bhanu Pratap and Bilal Ahmed, it is submitted that they cannot be relied upon. These witnesses only overheard some of the co-workers of Aras saying that Salim, another worker of the woodworking unit, had purchased the sleeping pills. It was never completely established that Salim gave these sleeping pills if he purchased sleeping pills to Aras. It is humbly submitted to the Honorable Court that it should also take note of the fact that the witnesses never saw Salim buying the pills themselves. This was only an overheard conversation and conversation of third party. It was never confirmed by investigating officers whether Salim actually bought sleeping pills and whether they were given to Aras or they were for himself. Just because Aras tried to buy some medicine at the pharmacy of Rajesh Lugade and his friend also bought some medicine, the same is a mere coincidence and should not be used to paint them in an incriminating light. It is further submitted that investigating team had found alleged murder weapon in the possession of accused number 2, whereas the testimony of these two witnesses to the police state that the murder weapon was thrown in a pond. There are material discrepancies in the testimonies of these two witnesses and they do not have evidences backing them. Also, the fact that Salim is not brought in as a prosecution witness points towards the innocence of accused number 2 in the allegation of acquiring sleeping pills. With regards to accused number 1 was working as a school teacher and she there were some arguments between accused number 1 and her family members with regards to the relationship of accused number 2. The same could not have been held to be a valid motive for her to kill her family
2
members.
minutes left.
She would not gain anything from doing such an act, given that she was educated and had financial backing. Also, Sarah called for help after discovering the bodies of her family members. This indicates that there was no untoward intention to begin with. If otherwise is to be assumed, she would have waited till morning and displaced all evidence completely from the crime scene before crying for help. With regards to accusation of sleeping pills, a blue smellless liquid was found in the stomachs of the victims. However, the same smellless liquid was not found in all the victims. If sleeping pills were to be mixed in the tea of all the family members, then the same should have been present in everyone's stomach. With regards to the mobile phone recovered from the possession of accused number 1, Sarah, it is stated that Sarah and others were in relationship was not supported by the family, they must have exchanged communication devices. This cannot be held to be a incriminating evidence, and it cannot be said that they conspired to kill their family. Lastly, it is a well-established rule in criminal jurisprudence that circumstantial evidence can be made the bias of an accused person's conviction if it is of such a character that it does not point wholly to the innocence of the accused, but shows guilt at some times. In light of all these issues raised, it is prayed to the Honorable Court that it finds the accused in this particular case not guilty of the offense, or pray for, and it is prayed that further investigation be done if the court is not pleased with the forensic report of the police.
Okay.
See, as far as the recovered articles are concerned, it is a case of the prosecution that everything was sent to FSL, forensic. Secondly, at the same time, the recovery is at the instance of accused number 1 and 2. The Panchnama are carried out under section 27. The 27 is an exception to section 25 and 26 and 162 of CRPC. Then in that scenario, once there is a statement which is available on the material which can be looked into and which is admissible in the eyes of the law, why it should be disbelieved?
Your Honor, first of all, with regards
Time
to
up for pleading.
can I reply to that question, Your Honor?
Yeah, please go ahead.
Your Honor, with regards to the forensic report, firstly, it is submitted that once a charge sheet has been issued and the matter is in the justice system, it is assumed that all investigation is complete in its nature. Here, the forensic report does not state anything with regards to whose blood was found on the stained shirts, what kind of tablets were recovered, what kind of sleeping pill tablets were there in the strip of 10 empty tablets, and if there was any blood on the axe that was recovered. It is simply stated that an axe was recovered from the possession of accused number 2. In light of these above arguments, I would plead to the court that the evidence should not be considered to be an incriminating nature for the accused.
Okay.
All right.
Yes, what prosecution want to say?
Made this, Your Honor, can I start with the argument?
Time up for pleading.
1 minute
You
can
can
be
start
given to
with
either side.
Witness examination.
Your Honor,
if
now
please.
Your Honor, the defense would like to call upon Dr. Shashank for cross-examination.
Go ahead.
Dr.
Yes,
Shashank,
go ahead.
yeah, Dr. Shashank, did the deceased, sorry, Dr. Shashank, can you say beyond doubt, with 100% surety, that sedation took place in this given case?
Yes, especially in Vasan and Hina.
Okay. What kind of tablets could have been used in this kind of sedation? Are they available only by prescription, or they are available as a generic medicine?
It's an outcome of a sleeping pills, and the sleeping pill is used for you smell less liquid.
Dr. Shashank, you are not answering my question. My question is, the sleeping pills which you say have been used, are they available as a general prescription, or they are?
He has not stated that which kind of sedation was used. All that the doctor has to say that sedation pills were used.
Your Lordship, the doctor just admitted that sleeping pills were used.
Exactly. The sleeping pills, the ingredients might be different.
If I may, Dr. Shashank, can you please clarify how are you stating that sedation was used, especially in the case of
counsel? Before switching the counsel, you need to take a permission of the court.
My apologies, Your Lordship. May I please take over from my co-counsel and ask a question to the
Why
witness?
you feel that your co-counsel is not competent?
There is no feeling of incompetency towards my co-counsel. I am only stating.
Once he has started, then can you take over?
Your Lordship, I ask for your permission for the same.
I have not permitted.
Very well, Your Lordship.
Your Lordship, I would like to ask Dr. Shashank that what kind of sedation had taken place?
There's a lot of background voices there. Please mute yourselves. Other parties, please mute yourselves. Okay.
Sorry, can you
Okay,
repeat
go
it?
ahead. Go ahead. Go ahead.
Okay, okay, Dr. Shashank. How logically that the deceased were first sedated and then they were killed?
It's not possible because it's intensity of wound while pressuring the weapon, while slaughtering the throat. I think
Counsel, it is not
be-
is it not logical that if the sedative pills are present in the body, certainly it has to be safely presumed rather, that it is before the death?
Your Lordship, it is better to make things more particular and clear than having assumptions or presumptions, Your Lordship.
So are you suggesting that after they were killed that pills were inserted in their stomach?
I'm not suggesting or inferring anything, Your Lordship.
Okay.
Your Lordship, now we would like to call upon Mr. Lala Khan for his cross-examination and examination chief.
Your Lordship, may I have the permission to interrogate or ask questions to the witness?
Yeah, please, counsel.
Yeah, please, please.
Lala Khan, am I audible? Hello. Mr. Lala Khan, can you please unmute yourself?
Hello.
Hello. Can you please state your name and your occupation to the court?
My name is Lala Khan and my occupation is a broker. I'm a broker.
Can you reiterate the facts, the events that happened on the night of 14th?
Yeah. After eating
You
my
are
dinner,
conducting cross-examination, counsel.
Your Lordship, I will get to the other questions in just a moment. It is necessary for me to reiterate this fact.
No, there is no need because it is already there in examination chief.
Very well, Your Lordship. Mr. Lala Khan, can you state as to how much light was present at the time when you were outside walking and when you heard the screams of Sarah?
I can't tell you the exact timing, but it was around 11 o'clock.
Not the timing. I am asking about how much light was present in the environment.
Oh, no, it was dark outside.
Can you
Only
conclusively
street lights.
say, did you check your surroundings before you proceeded to help Sarah or enter her house? Did you?
Not an eyewitness, counsel. So, where are you deriving? What is the relevancy? Section 3 of Evidence Act.
Your Lordship, I want to clarify from this particular question that Mr. Lala Khan did not miss out on any person walking away from the house or running away from the house, and just to establish that he and Sarah and the dead bodies were the only figures present.
Lala Khan has not stated anything of seeing any incident. All he has to depose that he entered
5
the
minutes
house,
left.
he heard the scream, he entered the house, found the bodies lying in the pool of blood, and Sarah was present. That's all. That
Okay,
is
Your
the
Lordship.
only material.
Okay, Your Lordship. Mr. Lala Khan, can you please state as to did you enter the house and how did you enter the house?
I entered the house from the main gate, and because I heard some screaming, so I thought something was wrong. So I felt to go and check that. So
And-
when, yeah.
And after you saw Razia and you took her to the hospital, what steps did you do just before taking her to the hospital?
I took her to the hospital because she was unconscious and she was bleeding. So first
did
thing
you
I did
rush
was
to the hospital?
Yeah, while rushing, before that, I have raised an alarm, which is set up in our colony so that everyone should know about this fact that this incident has been happened in our locality.
Your Lordship, it is submitted in view of the testimony just given by the witness that first of all, he entered the house and then he saw the dead bodies and Sarah. Therefore, the door of the house at that particular point was open. Secondly, before rushing to
He
the
has
hospital,
not stated, you have not put any question regarding that, whether the doors were open or not. You are
Okay.
presuming that.
Okay, Mr. Lala Khan, were the doors of the house open when you entered the house?
Yes, it was open. And first thing I saw was Sarah's father and mother.
Okay.
So there is all the possibility that us, while leaving the house, kept the door open.
Can you repeat, Your Lordship?
Then there is all the possibility that accused number 2 after committing the crime, while leaving the house, kept the door open?
Your Lordship, first of all, that it is not established that accused number 2 has actually committed the crime. That is just being claimed by the prosecution. A chain of sequence has not been established to prove doubt led beyond reasonable doubt. Secondly, I would also like to state and point out that before rushing to the hospital, and the witness specifically stated that he rushed to the hospital, in view of the same, he must not have closed the door while leaving.
Counsel, I will draw your attention to the 313 statement of the accused number 1 and accused number 2, wherein they admit their guilt. What more is required? Tell me.
Your Lordship, under section 24 or 24 and 25 of the Indian Evidence Act, and confession made to the police with regards to the guilt of
I
the
am
accused
talking about
cannot be
section
used.
under section 313, which is before the court.
It
is not before the police.
Your Lordship, can I just have a minute to look at the section?
I'm telling you, 313 section is during the course of the trial.
2 minutes left.
Your Lordship, I will let my co-counsel take this question.
Your Lordship, if I have the permission to speak.
Yeah, please.
Your Lordship, the statement was made before the investigating officer and not before the court, Your Lordship. In the statement of fact, it is written.
Counsel, I am talking about the admission, the denial with the case wherein accused number 1 admitted to the court when she was put in the witness box after conclusion of all the prosecution witnesses under 313. She was put a question, specific question, what she has to depose about it. She stated that it is all done by hers, and hers said that it is all I done because she called me.
Your Lordship,
they both end up admitting to the crime before the honorable court. It is not hit by section 25, neither it is hit by 26. And at the same time, the recovery panchanamas of all these incriminating articles are under 27, which is an exception to 25 and 26 and 162. I repeat this.
Your Lordship, I agree with you, but in this case, the statements were made by Araz and Sara in the presence of investigating officer, as stated in the fact sheet. It was never made in the in this honorable court. And
Sorry?
as far as the statements made by Araz and Sara were made before the investigating officer and not before this honorable court. It is there in the fact sheet, Your Lordship. By the Honorable Apex Court that so far as the law is concerned, a conviction can be based on uncorroborated testimony of an accomplice, provided the judge has a rule of caution, which experience dictation in mind and gives reason why he thinks it would be safe in a given case to disregard it. Interpreting the Honorable Supreme Court, it is submitted that the statement made by accused number 1 that accused number 2 had entered the house on the roof with a knife and killed the family members while she was sleeping alone in the other part of the house be discredited.
Your Lordship, in addition to that, it is humbly submitted that these statements were made in a state of shock when the accused had seen dead members of her family, and as such, the mental capacity of any human will be diminished, and it cannot be held reasonably that such statements were made in a sane sense of mind.
Counsel, I fail to understand one thing. The entire family was killed, and why your only client was left alive?
Your Lordship, Your Lordship, the accused, Sara, had specifically stated that she was sleeping in the other part of the house. Now, she being sleeping in the other part of the house, there is a very high chance that when someone came to commit the murder or the crime, they might have missed out on the person sleeping in the other side of the room. It is on prosecution to establish why she was sleeping in the other side and why she was not murdered along with her family members.
It is a duty of prosecution.
Your Lordship, the prosecution has brought forward the claim
that is your defense, that she was sleeping on the other side. So once you take that defense, that burden of proof is on you. The affirming party has the burden of proof according to me, right?
Okay, Your Lordship, even if we were to consider this, there is also the fact that Sarah was 2 months pregnant at the time, and the strip of tablets has not been identified by the forensic report. There is a very high possibility that she might be on medication, not feeling well, among other things, because of which she was in a
No, we
deep
are not
sleep
on
in the other
sleeping
room.
pills and the tablets. My question was something else.
Your lordship, in
But
any case,
diverting your answers now.
your lordship, in any case, my client being sleeping in the other side of the room does not negate the fact that all the evidences presented towards the conviction of the accused are very circumstantial and cannot establish beyond reasonable doubt that they have actually committed the crime.
But you both counsels are not answered my query regarding section 27, which is exception to 25-26.
Your lordship, please give us just a minute.
Your lordship, as according to your question, your lordship, it is upon the item of discovery. It is regarding the discovery of the item upon the statement of the accused. Now, the item so discovered hasn't been proved that the hasn't been proved that the item was used in the commission of the crime, your lordship. The prosecution failed to put forward any evidence before this honorable court that the said item recovered upon the statement of the accused was used in the commission of the offense.
All right.
Okay.
Thank you, your lordship.
Both of the teams are allowed to rebut on the point.
Okay, 2 minutes for rebuttal, right?
Yes.
Yeah, speaker number 2 of V11.
The accused were in the romantic relationships in their 20s. It was opposed by the
You are time and again harping on the issue of romantic relationship. I can understand relationship. How you are concluding that it was romantic also?
apology, my lordship. The accused number 2 was 2 months pregnant at the time of the incident, and the accused number 2 was desperate to get married with accused number 1 from escaping from the stigma of illegitimate child and becoming wealthy at a future by being the legal heir of the property. That's why accused number 1 and 2 had committed this offense. The public prosecution has proved the motive and the common intention of the accused number 1 and 2 beyond the reasonable doubt on the basis of the medical examination of the accused number 2 and the conduct of the accused number 2 and 1. The call records in the detail at the night of the incident. The accused number 1 has attempted to purchase sleeping pills from the pharmacist that the same sleeping pills which he had attempted to purchase were found.
Time up for witness.
No, it was the time for rebuttals.
Which were found from the possession of the accused number 2. The empty packet of the same sleeping pills has been recovered from the possession of the accused number 2. The accused number 2 has sedated a family member from this sleeping pill. The prosecution has proved beyond the reasonable doubt the preparation and the effect on the basis of the examination of the prosecution witness Pranu Pratap, Bilal Ahmed and Rajesh Lugade from the recovery seizure Panchnama of the accused number 2. The accused number 1 was working at the wood sewing unit, which was near Sarah's house. The ex-accused has taken from the wood sewing unit and came to the Sarah's house and killed all the family members of Sarah with the assistance of the accused number 2, except the Raja. After doing this, accused number 1 ran from the house of the Sarah and wrote the.
Still relate your argument with the facts which are available, evidence available on record. Relate it to it. This is not a storytelling competition.
Okay, sir. Therefore, the public prosecutor have proved the case beyond a reasonable doubt that the accused number 1 and 2 are guilty for the offence he had committed under IPC of 302 read with 34. The accused may given severe punishment to set the example that no one has tried to commit such a type of offence again in the interest of justice.
Time up for rebuttal. Your lordship, may I begin with my
VM
statement?
15, yeah.
Yeah, please.
Your lordship,
firstly, with the statement of the prosecution that they have established the chain of events beyond reasonable doubt, it is submitted to the court that the evidence has not been proved to be connected to the crime completely. There are lapses in the forensic report, and as such, it has cannot be conclusively said that anything recovered from the crime scene were relating to the murder. With regards to acts, the blood stains, if any, were not sent for further detailed investigation. The nature of the empty strip of tablets were not given by the forensic report. Also, along with the fact that the blue smellless liquid was not stated as with regards to its contents. Secondly, stating since the sequence of events has not been completed, there is also lack of motive on the side of the lack of establishment of motive on the side of the prosecution. They claim that since the accused wanted to get married, they killed their family. However, it is humbly submitted to the court that any sane person, and in this case, Sarah being educated and being a government teacher, would know of the consequences, and that too of killing the entire family. It is very far-fetched that she would have done the crime, and also
Are you suggesting that uneducated people only commit crime?
No, Your Lordship, I'm not suggesting that. However, I am emphasizing on the fact that her education level would allow her to think clearer, as is generally the case. In view of the above arguments, it is submitted to the court that it does not find the accused guilty of the crimes as charged by the prosecution, and acquits them of any charges.
Very well. We'll decide.
Adjourn for the order then.
We'll decide that.
Time is up for rebuttal. Time is up for rebuttal. We are done with the proceedings. Both of the teams are done with the proceedings. We will move on to the next team. There is a 2-minute break, I think so.
Okay, fine.
2-minute break between two teams. Okay, we will rearrange. We are done. VM11, we are done with the proceedings. You can leave the Zoom call. It is live on YouTube if you want to see the further proceedings.
Obliged, sir, but rebuttal is not audible to us.
Rebuttal has been done. It was the court has considered the rebuttal. Okay.
Okay, Lord.
क्या अभी शांत बैठ कुछ बोलना ज्वाइन करके रखना दिख रहा हूँ क्या मैं नहीं दिख रहा है क्या चालू हो गया
Mute yourself. Please mute yourself. Please mute yourself. You're audible in the Zoom call.
Okay.
I would like to call upon Mr. Amar Salve, our professor, to introduce the new judge as he will be joining us for further proceedings.
Thank you so much, Siddesh. I would like to introduce our this session judge, Advocate Mayuri Bane. Ma'am has a very vast experience in criminal side since long. Welcome you, ma'am, for this session.
Thank you.
We'll start with session now.
Prosecution team number VM. Like we team VM9 to further with the proceedings. Start with the proceeding with the permission of the bench.
Yes, you can proceed. You're not audible. Speaker one, you're not audible.
Yes, ma'am. Am I audible now?
Yes, yes.
The council seeks permission to address the bench as your ladyship.
Yes.
Much obliged. Now, may it please this honorable court, counsel will be appearing on behalf of the prosecution in the matter of State versus Sara and Araz in the accusation under offences of 302 and section 34 of the Indian Penal Code. Now, your lordship, the council number 1 will be dealing with issue number 1 and council number 2 will be dealing with issue number 2.
Okay.
Now, if your lordship and your ladyship are well versed with the facts, the council seeks permission to move ahead with the contentions.
Yeah, please proceed. We are already aware of the facts.
Much obliged. Now, your lordship, issue number 1 deals with whether or not accused number 1 and 2 are culpable for murder under section 302 or are they liable for murder under section 302. Your lordship, to understand 302, we have to understand section 300 and under which clause of section 300 the punishment for murder falls upon. Section 300 subclause 1, it specifically speaks that except in cases hereinafter, culpable homicide murder, if the act by which death is caused with the intention of causing death, your lordship, the action over here falls under this clause of section 300. Further, your lordship, 2 ingredients that have to be fulfilled in regards to murder. Number 1, which is mens rea, which is guilty intention, and number 2, which is actus reus, which is the wrongful act. And the guilty intention is set by in Commissioner versus Income Tax as well, and whereby it was defined what guilty intention was. Your lordship, your ladyship, I would also like to submit that to constitute a wrongful act, there has to be certain conduct that can be shown, a conduct of wrongful nature, which moves towards the wrongful act. Now,
counsel, let's focus on what is the material available to you.
Yes, your lordship. Now, your lordship, I would like to present the argument in a manner whereby the circumstantial evidence will go on to prove that the parties who are accused are liable for the offense that they're accused under. Your lordship, firstly, to establish that Sara and Araz were with a common intention, the first fact that they had a love affair. Secondly, your lordship, to show the intention of the family, I would like to bring your lordship and ladyship's attention to the fact sheet, whereby it is said that they often used to explain to her the hardships she would face if she goes against the community and wanted her to understand that Araz is not a suitable choice for her. This shows that the intention was of concern from the side of the family. Now, your lordship, I would like to move to the point of Sara's aggression. Specifically, I say aggression, your lordship, because if we again go by the fact sheet, it clearly states that when the family showed the concern, Sara would mostly end up quarreling with the family members. Your lordship, it got so bad and such a nuisance that the neighbors had to call the police and complain about this nuisance, what Sara had done. Your lordship, second instance of where it can be seen that Sara is aggressive is when the police call the neighbors. Your lordship, when the neighbors' statements were taken by the police, they had clearly said in their statement, categorically mentioned the fact that Sara, due to her rage, had committed so and so of crime. And your ladyship, out of rage, she had committed this. Again, I would like to emphasize out of rage. This was a statement of the witness, the neighbors. Now, your lordship, this shows the mental situation of Sara and Araz over here. Now, further, I would like
whether the witnesses made a statement that it is because of the quarrel and out of rage she committed a murder?
Your Lordship,
I don't see
there
that.
are two isolated statements. The second statement where they said that out of rage she has committed is on page number 2 of the fact sheet on line number 5, Your Lordship. And the first mention is on the page number 1, Your Lordship, para number 2.
Can you read it for me?
Proposition itself, Your Lordship. If Lordship permits, I would like to go further to contention. So, Your Lordship, Sarah and Araz, the conduct which we have to prove over here is very important. Your Lordship, they met frequently and they discussed the resistance faced by the family. This was, I would like to note the attention of your ladyship and lordship on the resistance point. Your lordship, they were not holding her back. They were not letting her meet Araz, nothing like that. They just showed concern. But in the mind of Sarah and Araz, they faced as though that there was resistance from the family. This constitutes that Sarah and Araz themselves had certain conceptions in their mind in regards to this. They used to meet each other. They used to discuss how to resolve the issue and so on and on. Now, I would just like to put one simple question in front of your ladyship and lordship, if I be permitted, that your ladyship, Sarah could have easily left the family. If she wasn't feeling acknowledged, she wasn't feeling right in the family, she could have left the family. She could have left and ran away with Araz. But why constitute to stay? Because your ladyship and lordship, because she was the only legal heir of the property. And if she wanted the property, the only way she could have received it is by the death of the family members. This is a doubtful fact in itself, your ladyship and lordship. Why did she not run? Why did she come to this conclusion?
Don't you think this is a presumptive value?
Your lordship, the presumptive value in this stands, but your lordship, this also comes under goes on to prove the circumstance of the case in itself. That why not? Then why this? Your lordship.
Counsel, sorry to interrupt, but can a criminal liability be passed on only on the basis of presumption?
No, lordship, not on the basis of presumption, but when that presumption is over there and it proves this chain of circumstantial evidence, then it can be used and admissible in the court of law, your lordship.
Let's see what is the chain.
Yes, your lordship. Now, even to show further the conduct of both the people, both the accused, your lordship, your ladyship, Araz had attempted.
5 minutes left.
Araz had attempted to purchase sleeping pills, right? Then, surprisingly, on the same fateful morning, Salim, one of his co-workers, had also purchased the sleeping pills. Your ladyship and lordship, this shows the
Araz has only made an attempt to purchase that pills.
Yes, your lordship. Yes, your lordship.
He did not purchase anything.
Yes, your lordship, absolutely. But the attempt to purchase goes on to show the wrongful conduct of the accused. And this goes on further to prove the chain of the events, your lordship. Now, your lordship.
To complete the chain, this was the same pill which was found at the place of that disease, which the Araz has attempted to purchase. No. What is the chain to link this or establish this fact? There is nothing.
Your lordship, the sleeping pills being attempted to purchase and categorically Salim, a co-worker, purchasing it on the same day. This goes on to prove the circumstance that was created by accused, your lordship.
Is there any material to show that Salim in turn, after purchase of that sleeping pills, in turn have given it to us?
If your lordship permits me, like in my further contention, I will prove and satisfy your lordship's contention as well. If your lordship permits. Much obliged. So I would like to bring your attention now to the material facts, your ladyship and lordship. And please note, your ladyship and lordship, that the investigating team had arrived 5 hours after the first information received by Lala Khan. Now, your ladyship and lordship, the investigating team arrived. They recovered blood-stained pillows. They recovered rope of cot. On the instance of Araz, they had recovered the murder weapon axe and they had recovered a blood-stained shirt. On the instance of Sarah, they had recovered a blood-stained shirt, a strip of tablets, with 10 tablets, which was empty. And they further recovered the phone and everything else, your ladyship. Now, what I would like to say, your ladyship and lordship, in front of you, the question I'm presenting is that it would be fine if all these things were discovered quite after the event had occurred. Many contentions can be put forward by my learned friends as well in regards to this. But this was discovered 5 hours after the incident had occurred. This creates a certain doubt in the mind whether or not how blood-stained shirts and blood-stained pillow covers and bed and everything was recovered just 5 hours. And it was recovered at the instance of both the accused. And further, your ladyship and lordship, the story that Sarah had narrated of the robbers coming so on and on was not even believed by the police officers themselves. The police officer negated the story and arrested Sarah for inquiry, and then further arrested in suspicion Araz as well. So the story itself is flawed, your lordship. Now, one last fact I would like to submit.
2 minutes left.
Yes, last fact I will submit is that they both incriminated each other, and as per Section 27 of the Indian Evidence Act, it is admissible when the statement is made to lead to a discovery of a certain fact. Now, if your ladyship and lordship permits, issue number 2 will be dealt with counsel number 2.
Counsel, interrupting for a moment. Now, since you are emphasizing on the issue of 5 hours delay, that even after 5 hours of arrival of investigating agency, this so-called incriminating material were recovered. Don't you think that in fact goes against you? The theory of plantation cannot be ruled out during these 5 hours?
Your lordship, but this was all recovered at the instance of Sarah and Araz, who were not even present at the scene of crime. This is what makes it very doubtful, your lordship.
Even I'm saying so, but it is very doubtful. Recovery itself is doubtful. Don't you think so?
Your lordship, the police arrived at the house and recovered this. Right? They recovered at the instance of Sarah and Araz something different entirely, which corroborates to the evidence that was recovered at the house itself. And the theory of plantation can only work, your lordship, if a time frame can be a little more.
1 minute left.
This seems a little doubtful, your lordship, in itself. Now, if your lordship permits, counsel number 2 will present her argument in issue number 2.
So you are concluding that everything is doubtful?
Your lordship, it is doubtful from the point that the accused, what they're stating, what the accused is stating itself is doubtful, your lordship. That is what I'm trying to present over here.
All right.
Yes, much obliged, your lordship.
Let's hear the counsel number 2.
Your ladyship and lordship, issue number 2 deals with whether common intention lies between accused 1 and accused 2 for the offense. So the two main ingredients of intention as per section 34 of the IPC are whether common intention to commit a criminal act, and there must be a participation of all persons doing such an act together. Your lordship, both the ingredients are fairly satisfied here because both the accused have faced resistance from their family time and again. They met and they discussed how to resolve this. I would like to put a light here on two judgments.
Timer for pleading.
Your lordship, your ladyship, if I would get a little more time to just put my content.
The organizer to decide about the timeline.
Okay. Can I please get like 2 minutes? Your ladyship, lordship.
Yes, allowed.
Okay, thank you. Much obliged. In the case of Mohammad Usman versus State of Maharashtra, it is clearly said that common intention of the accused, and therefore it is impossible by the way of direct evidence here, and circumstantial evidence has to be relied upon. So this has to be shown by the way of looking at statements, firstly, conduct, and acts of the respondent. Now here, statements of witness can be taken into consideration. The conduct of Sarah, time and again, of how she's created nuisance and which has caused problem to the neighbors, and the acts of the respondents of how they've shown concern towards Sarah.
Come to the point of the facts of the case. We do not want to discuss the section here.
Okay.
Talk about the case precisely.
Yes. Okay. So here the ingredients, which is the common intention, first of all, because they wanted to be together, is very important, my ladyship, my lordship, and how they've done the crime together. These two ingredients fairly satisfy the section 34 of the IPC. And if the lordship is now satisfied, I will just put forward the prayers to the honorable court.
It's up to you.
Okay. So convict, we would ask the honorable court to convict the accused Sarah and Aras under section 302 and 34 of the IPC and declare a sentence of death, imprisonment for life, and liable to fine, and pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. If your lordship and ladyship is satisfied, we would go ahead with the examination in chief.
Our satisfaction is left to judgment.
Okay.
We'll decide that later.
Okay, your lordship, ladyship. Much obliged.
You can call upon the witnesses.
If your lordship permits, counsel number 1 will be dealing with certain witnesses and counsel number 2 with another.
Yeah,
I would
please
like
proceed.
to call upon the witnesses. First, I would like to call upon Dr. Karnik.
Dr. Karnik.
Yes, Your Lordship. Dr. Karnik was the one who had presented the injury report in the case of the.
Wait a minute. Dr. Karnik will be here. Wait a minute.
Your Lordship, if you could bring your attention to Exhibit B as well, Your Ladyship.
Yeah, Razia's injury certificate.
Yes, Your Lordship. You signed it.
Yeah, please proceed.
Pardon?
Dr. Karnik, am I audible to you? So can organizers please check on
I
the-
can't hear.
Can you hear me, Dr. Karnik?
Dr. Karnik, can you hear him?
Am I audible to you?
Hello, can you hear him, Dr. Karnik?
Very little bit.
Please, can you check your connection a bit?
Your Lordship, till Dr. Karnik comes with the proper connection, can I proceed with my another witness?
Okay.
Yes, please.
I'd like to call upon Dr. Shashank, Your Lordship.
Yeah, please proceed.
Is Dr. Shashank present among us?
Shashank is present.
So, Dr. Shashank, I'm audible to you, I'm assuming, right?
Yes.
So, please state your name and your qualification for the court.
I am Dr. Shashank, Mastering Surgeon in Udhamnagar Government Hospital.
Right. On which victims did you perform your examination?
I performed on 3 victims named as Vasan, Tina, and Naj.
Now, what does it mean when blue liquid is found during autopsy?
It's an outcome of surgery pills, which is also called as sleeping pills.
Pardon?
It's an outcome of sleeping pills.
Outcome of sleeping pills. All right. Now, last question to you is the injury caused on the victims. Would it substantiate to cause death of any individual that it would be inflicted upon?
Sorry?
The injury that was inflicted upon the victims who you did your autopsy upon, if that same injury has been inflicted upon any other individual, will that resultantly lead to death of a person?
Yes, so all 3 were slit-throated and asphyxia was found.
All right, thank you. If I can get Dr. Karnik, if his connection is established.
Yeah, Mr. Counsel.
Dr. Karnik, please state your name and qualification for this court.
Hello.
Please state your qualification for this court, Dr. Karnik.
Can you state your qualification?
Can you speak a bit?
Hello.
Yes.
Hello, Dr. Karnik, can you state your qualifications?
Your Lordship, Your Ladyship, I would again like to move forward with another witness of mine because of technical.
Yeah, please.
I'm Dr. Karnik,
Yeah, Mr. Karnik is available.
BGM Hospital, Udhar.
All right. Dr. Karnik, on which of the victims did you perform your examination on?
Victim named Razia came to me on 15th of April 2020.
All right, thank you. Now, could you describe the injury and its effect if inflicted upon any individual?
Sorry, counsel,
actually, it was made near about at 12 p.m. 12 a.m. at night. It's a little bit incised wound, 4-meter cut on the throat.
4 meters?
4 centimeters.
Maybe lethal.
Achha, Dr. Karnik, one last question.
Sorry?
What was the nature of the injury?
But I can't listen to you.
Your Lordship, please permit me to move towards the next witness.
No, please, I need Mr. Karnik to speak precisely on this one point.
All right. Dr. Karnik, please, could you state for the court what was the nature of the injury?
Sorry, sir, your voice is breaking.
Could you please tell the court what was the nature of the injury?
Yeah, Dr. Karnik, am I audible?
So he is having some connections issue. We can proceed with someone else. He's
Proceed.
facing very long
Yeah,
problem.
please, please.
Much
We will fix it later on.
I would like to bring upon a witness, Mr. Rajesh Lugade.
Pharmacist.
Yes, Your Lordship. Stand correct. Mr. Rajesh Lugade, is he available?
Give him 2 seconds.
Hello.
Yes.
Yes. Am I audible now?
Yes, you are. Mr. Lugade, can you state your occupation for the court?
I'm a pharmacist.
Mr. Lugade, who attempted to purchase the sleeping pills from you on the fateful morning?
Counsel, you are presuming that someone attempted. This is a leading question. It is not allowed.
All right, Your Lordship. Obliged. Mr. Rajesh.
Yes.
On the fateful morning, who purchased sleeping pills from you?
Again
the same question you asked the counsel.
You are not supposed to ask any leading question. You can ask what he has to say about this case.
All right. Mr. Rajesh, can you please narrate the events and the submission that you have provided to the investigating officer?
See, precisely, I don't remember many things because there are multiple customers who come to my store. So I don't remember, neither do I remember the day, nor do I remember the timing or anything. I don't remember anything very precisely. But Aras, he's someone who stays in a nearby locality. So he keeps coming to my store. That is why I could recognize him. But that day he gave some he was not having any prescription. So that is why I did not provide any medicines to him.
All right, thank you. If your lordship permits, counsel number 2 will be dealing with the other witnesses. Much obliged.
Your ladyship and lordship, I would call upon Mr. Lala Khan. I would like to call upon Mr. Lala Khan, am I audible?
Wait a second. Wait a second.
Okay.
Yeah.
5 minutes left.
Mr. Lala Khan,
Hello.
can I start? Can I begin? Yeah.
Yes,
okay.
yes.
Okay. For the record of the court, can you please tell us what is your relation with the accused, or how do you know the accused?
We are neighbor. That's how I know.
Okay. Okay. So, what are your thoughts on the accused as a neighbor, or her behavior as a neighbor?
Actually, the whole family is short-tempered.
Whole family. Okay. Okay.
Yes,
Can you
yes.
describe any incident which makes you say this?
They actually, on regular basis, I can say, they used to quarrel among them. So that's how I can say they are short-tempered.
Okay. So can you describe us what exactly you discovered when you entered the house of the accused on the
Counsel,
date of
you
the
are
crime?
presuming that he has entered. He has not stated anything about that.
Okay. All right. Okay. Can you tell us the chain of events that happened that day, Mr. Khan?
Yes. Actually, I was walking in the night after my dinner. Then I heard some noise coming from my neighborhood. Then I felt something was wrong there. So I went to see what's happening there. So as I reached there, the door was open little bit. So I opened the door and I found Sarah's father and mother. They both were dead. And in the adjacent room, I discovered 3 more dead bodies. They were Sarah's brother, sister-in-law, and their child.
Okay. Did you see any sort of struggle or any breakage of any material in the house?
Yeah, there was vase that was breaked, and Razia was unconscious. Her neck was slit slightly, and she was bleeding.
All right. Thank you, Mr. Khan. Your ladyship, lordship, now I would like to call upon Bhanu Pratap for the examination.
Yeah, please.
Yeah. Thank you. Much obliged. Mr. Bhanu Pratap, am I audible?
He will be there. Wait a minute.
Okay. All right.
Yes.
Okay. Mr. Bhanupratap, can you tell us what position of authority do you have in the village?
I'm the blockhead of the village.
Okay. Can you tell us what you testified in front of the investigating officer and what did you hear from the friends of the accused?
Madam, you cannot directly put a question, leading question that what he heard, he has not stated. Secondly, you cannot confront the witness and you cannot try to extract whatever statement he has given to the police.
Okay, okay, obliged. Mr. Pratap,
2 minutes left.
Mr. Pratap, can you tell us what do you know happened on the day of the incident?
The day of the incident or day prior the incident?
Prior the incident, prior the day of the incident.
Well, on 14th April, I was near the pawn shop of Mr. Bilal Ahmed, and a few meters away from me, friends of ours were standing and having a chat, and one amongst them spoke something like, one of the friends of ours is going to buy sleeping pills.
Okay, do you know the name of the friend of the accused?
No.
Okay. Anything else that you remember from the day, prior the day or on the day of the incident?
No, that's all I can recall, and that's all I
Last 1
testified in.
minute.
That's
Okay,
all I
okay,
testified
all right.
in front of the investigating officer.
Okay, all right.
Am I
Thank
done?
you. Yes, yes. Thank you. Your Ladyship, Your Lordship, now I would request Bilal Ahmed for the examination.
Yes.
Mr. Ahmed, am I audible?
Yes.
Yeah. Mr. Ahmed, can you please tell me what exactly do you know happened on the day of the incident or prior to the day of the incident?
Yes, before 1 day before the incident, on the 14th April, I was preparing a pan for blockhead Mr. Bhanupratap Singh on my shop. And few meters away from my shop, the group of Ara's friends were gathered, and someone from the group was telling to his group members that Salim purchased the sleeping pills.
Okay, so you heard sleeping pills, purchasing of sleeping pills.
Yes, yes, yes.
That- is
I
that right?
overheard that.
You overheard that. And Araz was
Yes.
there that time, right?
No, Aras was not there.
Okay, but his friends were there.
Someone from that group was telling to his group members. I don't know the names of the group members.
Timer for witness.
Okay, okay, okay. Thank you, Mr. Ahmed.
Okay.
If your Lordship, Ladyship is satisfied, the council has completed with the examination in chief and would ask this honorable court for leave.
Counsel, we are just confused at what you were trying to extract from the witnesses. What you really wanted.
Exactly. I mean, the source of information and the way that you're proceeding is really a bit confusing as to what you want to extract from the witnesses, actually.
Salim could have been a best witness to narrate about all these things. He could have been a key witness. You have not examined him.
But Your Lordship, Your Ladyship, Salim was not present in the witness list provided to us by the college.
But do you agree that Salim was the best witness?
Salim would have been a good witness, Your Lordship. Agreed.
So can you rely upon the witness of pawn shop owner?
Your Lordship,
He's talking about something overheard conversation that too is a hearsay evidence, and there is nothing to connect Salim to Araz also.
Your Lordship, Your Ladyship, the
See, we are on the part of admissibility of this kind of evidence.
yes.
Exactly. When you say about Salim, that can also be a benefit of doubt given that with Salim. Can you just exactly prove that is the same Salim that they're talking about which they overheard?
Yes, Your Lordship, Your Ladyship, because this Salim that they had so-called overheard was the co-worker of the friends of Araz.
But
So
did
there is a
any of
relation that has
did
been
any of
created.
your witness mentioned it?
I'd like to plead ignorance, Your Ladyship, Lordship.
All right.
But Your
That's-
Ladyship, Your Lordship, the chain of events and the questions that we asked in our examination in chief, we wanted to prove the point that what the medical examiners had procured what the exhibits had shown go in concurrence with what we are trying to prove as an argument. That there is.
Sorry, counsel. What you wanted to prove is a different aspect. What you have proved after examination is a aspect which will be considered by this court.
Yes, Your Lordship. Obliged.
Obliged. Thank you.
My lord, with your kind permission, can I interrupt?
Please.
Sir, I'm available. I'm Dr.
Yes,
Karnik.
yes, you are audible. So you are representing the defense.
Hello. Hello.
Your Lordship, Dr. Karnik said that he's available for a statement. But Your Lordship, we concede with the arguments in examination in chief and would leave up to Your Lordship and Ladyship for further arguments.
Please. Yes, Speaker 1, VM 17.
Yes, yes, my lordship. My lordship, firstly I'll ask your permission to drink water as I have a bad throat and I'm not well.
Yes, yes, yes. You are permitted.
Yeah. Okay. So my lordship, I'll directly come to the material that were provided. If we come to the exhibit A, which is the FIR, the very first line of the FIR, my lordship, District Bodhian Police Station, Udamnagar, year 2020, and the FIR number is 184/17, and the date is 15/4/2020. Here, my lordship, is my area of interest. If the FIR number is 184/2017, how did it come to be lodged in 15/4/2020?
Good observation, counsel, but it's a typographical error.
My lordship, then.
But anyways, we are impressed.
My lordship, the second thing I'll come point number 3, occurrence of offense.
Okay.
Occurrence and offense is day is Monday, date is 15/4/2020. My lordship, I request you to check the calendar, my lordship. I request you to check.
Counsel, shall I ask you one question?
Yeah, ma'am, please.
Because of all these technical errors, do you deny that the offense has not taken place?
My lordship, my lady, I'm sorry, my lady, I'm sorry, but this was what provided to us. This is the material that we studied. So it is not our.
All right, this is a type of what my sister judge is trying to tell you, that whether the technical errors will take away all this criminal liability. Or
exactly, and I think you have very less time to prove your case instead of all these technical
my
errors.
lady, my lady, if I may, yeah. My lady, but there are n number of ground in this FIR itself. N number of grounds which are found in this FIR in one single exhibit, which should not be excluded.
Are
That
you
is
suggesting
my
that
prayer
that incident has not happened?
No, I am suggesting that the investigation in this case was not conducted properly, and this is the result. That is my case, my lord. The investigation was not conducted properly.
But mistakes in date will not come to suggest that the investigation is not proper.
Counsel, can you tell me the date of Exhibit B?
Yeah.
Can you tell me the date of Exhibit B?
No, it is not mentioned over here. No date is mentioned. The date is 15/4/2020. 15/4/20, and the reference number is given. Exhibit C, yeah, 15/4/2020 at 12 a.m.
Exhibit D?
And say 15/4/20 at 12 a.m.
Then, counsel, why are you wasting time? You already got less time to speak.
No, my lords. Okay, ma'am, I'll continue with it because it was a ground I saw. My lordship, here in the injury certificate, here in the column number 2, the size of the injury length, there is only given 4 centimeter cut. Normally, it should be given the length is 4 centimeter, then the breadth is so and so, and the width of the injury is so and so, which are very, I'll say, a prominent thing in such a case. In case of murder, here Razia was the injured person over here. The injury is only given 4 centimeter cut on the throat. But what was the breadth of the injury? What was the width of the injury? Everything is absent here. My lord.
See, the case is that your client committed a murder.
Yeah.
And you are defending your client who has been charged for murder. Whether these technical issues will save your client.
These technical issues will play a prominent role in saving my in the final argument. These technical issues will play a prominent role.
Counsel, have you done a research
No.
on what is? Listen to me first.
Yeah. Sorry, lady.
Have you done a research as to what is the length and breadth of an axe? Can a 4 centimeter injury be made on the throat of a person?
Exactly. This is my point. There are no dimensions of the axe. What is the length of the blade of the axe? What is the breadth? Even a axe has an handle.
I don't think you are getting a query of this code. The query was something else.
Sorry.
Yes.
Sorry.
So then I'll ask you one step further. If you have you read Exhibit B properly?
Yeah.
Do you know what do you know what is diclofenac? The tablet which is given, diclofenac injection.
No, ma'am, I'm not familiar with it.
Do you know tablet ibuprofen why it is given?
No, ma'am. But one of these injections were given as a painkiller.
Exactly. So you think 4 centimeter cut and then only a painkiller, and then only ibuprofen?
No, ma'am.
Then?
No, ma'am. But I was making my case over here because the technical grounds were
Don't make it half.
prominent.
Don't put your case half, counsel. It is like only one side that you're reading and the other side is in dark. Justify each and every sense of the Exhibit B now.
Of Exhibit B. Okay.
Counsel, it is an incised wound.
Yeah. I was, my lordship, I was prepared for all the technical grounds, but now the technical grounds were given a tag of mistake.
Wound,
yeah.
Whether that wound is sufficient to attract the ingredients of the offense. Now, basically, concentrating on the surviving witness, we should more concentrate on the injuries which are their victims, deceased
victim. Yeah, I'll come on that also. I'll come on that. When the very first question which came to my mind when I went through this is that Lala Khan entered into the house. In the entire written report, there was nothing mentioned as what was the intention of Lala Khan entering the house during the chief examination. Now he heard something and then he entered.
Now you want to check the intention of witnesses.
Why would someone enter a house? He should have some. A neighbor should have an intention if he is going to ask something, if he is going to help.
Counsel, he has given a reason that he heard the noises and therefore he rushed to that place.
It is, sir. It is not. It is not mentioned in this material. It is mentioned in the chief examination. That is what I'm making the case. If you are giving us a material, it should be concrete, so we can argue on it. This is my case, my lord. My lord, I'll come on the point. I'll come on the point. I'll come on this point. Here when the medical was conducted, medical examination was conducted, my lord, there are no chemical analysis report. If they are making the case that sleeping pills were given to the deceased victims, then CA report should have been conducted by the medical officers. The medical CA
Where
report
do you
is
get
also
this law that medical examination cannot be done in the absence of CA reports? Where do you get that law?
No, my lordship, it can be conducted, my lordship, but I am saying when such things, when a toxic ingredient is given to a person, then CA report is very important. My lordship, further I'll come on the point.
Counsel, are you disputing the homicidal death?
Yeah, I'm disputing the homicidal death because I'm not disputing it, but the intention, the mens rea, I am targeting the mens rea of my client. The mens, because I don't think if
then focus on that.
crime is my lordship.
Focus on that.
Yeah. My lordship, I'll come on that also. Here, according to the investigation made, it is clear that the accused number 1, that is Sarah, was found at the spot of the incident. Now, if she committed the crime, why the question arises why she would be on the spot of the incident? If she committed the crime and if her ultimate aim, as the prosecution was proving her ultimate aim was to a relation with Araz, then after committing the crime, she would have flown away with him. Why was she sobbing on the incident? Why was she with a deceased victim? This is my one statement, that what is the mens rea of a person, that if he has a mens rea to commit an offense, and even they are proving that she committed an offense, and that is the actus rea, then why would someone be at the same place of the incident which they themselves had executed? This is one point I would like to say. Now again, my lordship, I was very like observing the other presentation, and you, my lordship, I'll address you. You said that according to the 313 statement, the last paragraph, both the accused has admitted their guilt. But here it is written, while in the police custody during the examination, the very first line, the accused denied confessing to the crime. If they're in police custody, my lordship, how will they how was 313 conducted? 313 should be conducted
Last
after
1 minute.
313 should be conducted after the chief examination and cross examination. After that, the accused should be taken in the witness box, and at that time 313 should be conducted. But no, but 313 was not conducted. Like I don't feel like it is my study that 313 must not have been conducted as they were in police custody. My lordship, here in this entire story, I'll bring this to light. The very first line, Sarah belonging to minority committee, the prosecution again and again is trying to point out one single thing, that because of the communal batter, that because of the casteism, that because of that he is from a lower community and she is from the higher community, they are like proving this fact that
Counsel, how will you justify this theory put forth by your client that the robbers came and they did what they wanted to do, but the only thing what about the mens rea of the robbers that left only Sarah? How do you justify that?
My lady, I'll come to this point also, but after examination of the witnesses, I've in the final argument, I'll put for.
Counsel, what about the recovery at your instance about the incriminating materials? Under section 27?
Incriminating material, yes, my lordship. These questions will be asked to the medical officer if they came at the place when
medical officer is unconcerned with all these things.
When the investigation was made and such articles were collected from the room, were seized according to section 52 of the CRPC, power to seize weapons and other. My lordship, I'll address you here. No,
please elaborate section 52.
Like ownership of a material.
Counsel, let's read section
power
52
to seize weapons. Okay.
How that will come to your rescue? Let me understand.
Section 52 of the power 50 section. It will not come to the rescue. I'm just implicating this power.
I'm trying to understand. Like
weapons.
I'm also learning something.
Power
that section
the police
of CRPC will come to your rescue. Let's hear from you how.
It will not come to my rescue, but according to section 52, they have seized the weapons. The police have successfully seized the weapons. Then after seizing the weapons, did they conduct did they collect the fingerprints as such? Who was using this weapon? If Araz was using the weapon and Araz was also in their custody, did they match the fingerprints? Who was the owner of that X which was used to murder? Did the police conduct this inquiry?
It is sent for FSL and FSL report is pending.
Yeah, FSL report is pending. That is one part. But whose blood was it? My lordship, there are n number of contradictions in the entire material. But the contradictions was given. I'll give you 4. But they
I'm just asking for 2 contradictions.
But these contradictions are we giving the name of mistakes. That is why I feel.
Counsel, you are taking murder trial too lightly.
No, my lordship, I'll come to one point which the prosecution during the chief's examination had asked Lala Khan. Lala Khan in his chief examination has clearly mentioned that the family members of the accused were aggressive. They used to fight. They used to fight among themselves as well as they used to fight among others. This show the mentality of the family members. So if their intention is to fight, then how can they implicate that because of this matter they have been fought with someone else? They would
So
have fought
you
with someone else,
Council,
and as a
council,
rivalry, as
you
a
council.
want to say
revenge.
council,
Yeah,
council, you
ma'am.
want to say they fought with
We
the
are
robber
not
and they
having
had
any political meeting here and political
No,
speech.
I'm
We are
not coming
talking.
on political grounds. Yeah,
no, council.
they
See what
here.
what you mean to say something like that they fought with the robbers and that died between themselves
No,
only.
no, no. I'm the robber. The robber. I'm not concerned about the robber. I'm not involving the robber part in this case. Also, I'm just
So
trying to
what do you want
explain.
to say?
And
What do you
yes,
want to say when you justify Dala?
the
He
mentality.
doesn't want to involve robbers. He's admitting that
Yeah.
it's his her client.
No,
His client.
Exactly.
no. I'm not admitting that.
Exactly.
My lordship. They might. My point is the case that I'm making here is that uh, the family members of the accused number one Sarah were aggressive and they used to fight among each others and others
That's more
also.
the reason for a motive. That is more the
Yes,
reason for a motive.
yes,
For Sarah to kill.
but there for Sarah to kill. No, but my lordship, I'm implicating it here also. I'm implicating it in other way. In other way, I'm implicating it that the family members of Sarah would have fought. Yeah, I'm trying to take this scenario in a different. I'm showing the scenario with a different view that the family members of Sarah would have been fought with someone else. Would
I'm
have fought with,
sorry,
and
council.
that person.
I guess what is running in your mind is something else, and what you are arguing is something else.
Yeah.
No, my
Council,
Because
lordship.
we
just
are
a
not
minute.
understanding anything.
Council,
Okay,
I'll ask you one question on this
I'll be very
theory.
straightforward. Yeah,
Council, just a minute.
yeah,
One question on
yeah.
this theory of yours that you are saying that they must have
Yeah,
fought with someone else and that someone else must have came and killed them, right?
yeah.
Huh? Now, just
Yes,
come to page
yes,
number
yes.
3 of the statement of facts. Yeah, para number 1, last line. Just read that line. Additionally, I
Para
want you
number 3.
page number 3, para number 1, last
Page
line.
number 3, para number 1. Page number 3, para number 1, last line. To the contrary, Aras confessed and that he reached at the house only on the request of Sarah.
No. Page number 3,
Then
Council.
3, yeah. While in the police custody, that is the
No.
of my.
That, see, there's a statement. I'll read it. Additionally, the call records and details.
I got it.
Read that.
Yeah. Additionally, the call records and the details of the conversations between the accused on the date of the incident were also obtained.
Now, how do you justify this? With your
Because
theory.
because Aras
Is that
used to
someone
work.
else? Is that someone else? The other person named Aras?
No, I'll come to that also, ma'am.
When did you come?
The very first paragraph of the mood proposition, the very first paragraph, the second last and last Sunni community, it is considered to be a lower community, so and so dropout. Aras was a class 6 dropout who worked at a wood sawing unit in the vicinity of our house. He used to work in the vicinity of our house. So if he had his cell phone, then throughout the day he is working in the vicinity of our house. So when these call records were when everything call records and details were recovered, so it is probably because he was in the vicinity of our house.
What
That
about
is
the
why.
calls between them?
So they are they are admitting they are in a love affair, but their love affair is not the cause of this murder. Instead of this murder, I'll use the term mass murder, because 5 people were killed, and this is not a petty crime, killing 5 people including one infant. But the thing is, the presence of the accused number 1 itself crashes the mens rea completely, because if she had committed the murder, then why would she be at a place where she committed an incident? This is my
See, that
case.
is the case of the prosecution, that it is a well-planned murder. And that is a part of planning. She stayed back.
To the defense, my lordship, I'll add here. I know, but I've heard like this is not a storytelling competition like you addressed other councils also in previous.
See, to
But
add
so
something, you
contrary,
first
my
you
case,
say something.
I need some material. I need some material to it, but I don't have material to it. I am just making a suggestion here. My lordship, I don't have a material, but I am just making a suggestion over
You are
here.
not here to suggest something. You are here to defend someone.
The prosecution case that it was a well-planned murder. I deny the entire prosecution case. Sarah was in her house. She was in the other room of the house while this
Counselor, I'll ask
entire
you one
incident.
question. I'll ask you
Yeah,
one
yeah, ma'am.
question.
Yeah, ma'am. Yeah, ma'am.
What was the weapon used in the murder case?
The weapon which was recovered is a axe, but Sarah, according to Sarah's statement, which it is a contrary, she herself has stated that it was knife and killed everyone. But the weapon which was recovered is axe. Yes.
Is axe, right? So where does this person named
Yeah.
Araz works?
He works in a wood sawing unit where axes are used. I'm
Exactly.
aware of it. I'm aware of
Exactly.
it. Someone might. This
So
doesn't mean that other people do.
shall I
No,
take your awareness as acceptance that
no,
act,
no. My lord.
let
Yeah,
me
sorry,
complete my
sorry.
question.
My apology. My apology. My apology. Sorry.
So do you accept this fact that getting hold of a weapon just like an axe was possible for Araz?
It was possible for him, but he committed the crime. I'm denying it because on the other side, axe is not a personal thing
See,
to
we are
maintain.
not
Anyone
concluding
can use.
anything. We have not said that he has committed a crime.
Yeah.
You are
Someone else
pushing.
can get hold of his axe. Someone else can also get hold of his axe, my lordship. In fact, there is there is nothing obtained in the police report that the said axe belongs to Araz. There are no fingerprints recovered, or even if Araz bought this axe from somewhere, if from a shop or made from
Anyways,
someone,
counsel,
it
we
is.
have heard you a lot. Let's
Yeah.
proceed further.
Yeah, my lordship.
Yeah. Anything else?
No, my lordship. Thank
That's
you.
all. Yeah.
Are we done with the proceedings of both of the teams? Or anybody want to rebuttal the points?
Your Lordship, if your ladyship and lordship permits, then we would like to rebut.
Yeah, please.
Yes, please.
Your Lordship, I'll be rebutting exactly on the points that have been specified by my learned friend. Firstly, Your Lordship.
At least you understood that what points he has raised.
Yes, Your Lordship. If Your Lordship permits.
Yeah, please.
Yes, obliged. Your Lordship, in regards to the observation and the typographical error, which was rightfully done by Your Ladyship and Lordship, in furtherance of that, I would like to mention that in the case of Supreme Court, whereby the apex court in J. Samuel versus Tattu Mahesh, the court had held that the claim of typographical error would be baseless. First point, Your Lordship. And the second point, Your Lordship, I would like to speak in regards to is if she was sleeping on the other side of the house. One point that was mentioned by my learned friend is that she was sleeping on the other side of the house. So, Your Lordship, just one fact that I would like to mention. As per the supposed story of Sarah, that the robbers had come and done this and that. Your Lordship, Lala Khan, when he had entered the house, as per the facts, he went to the adjacent room and he found the bodies in the adjacent room as well. Your Lordship, it can be perceived from this that the robbers were going scouring throughout the house. That the robbers, if the story be true, robbers were scouring throughout the house and they went to the adjacent room as well. Why not to Sarah's room? Your Lordship, this creates again a big doubt in the mind of the story of Sarah that she has made it, and the story seems to be concocted, Your Lordship. Thirdly, Your Lordship, I again agree with Your Lordship and Ladyship's observations in regards to this, and I would like to satisfy the court in this matter in regards to length, breadth, and height of the cut. Your Ladyship and Lordship, the injury certificate itself, in the title, it speaks length, breadth, and height, and under it shows the amount. And 4 centimeter is length, breadth, and height equally. So length 4, breadth 4, and height 4. This can also be perceived from the injury report, Your Lordship, just to satisfy the court further. Now, if you'll, one more point that I would like to present in regards to the analysis.
So done with rebuttal time is up, sir. Rebuttal time is done for the.
If your ladyship lordship permits, just one more point of rebuttal I would like to present.
My lordship, even I would like to interrupt.
Yes.
Be quick.
Yes, your lordship. Your lordship, in regards to the point raised by a learned friend that she would say knife, that she was not aware of the murder weapon being axe. Your lordship, it is in adherence to what she has been doing throughout the case itself, where she has been lying. She has said on purpose that knife is there to show that she is innocent in the matter and so on and on. Your ladyship and lordship, categorically it can be understood by the facts presented and submitted to your ladyship and lordship that a crime has been committed under section 302 in concurrence with section 34. This is our submission to your ladyship and lordship. Much obliged for your time. Much obliged.
My lordship, I'd like to add one thing, if you may permit me.
30 seconds.
30 seconds. Okay. My lordship, I'd like to further add one thing to you. If they were given pills, like my learned
Don't add
friend
things to
said.
me. Add things to case. Your
Okay.
submissions. Okay.
My learned friend just said the length, breadth, and depth is 4 by 4 by 4. Did the accused insert a cube in the throat? 4 by 4 by 4 is the dimension of a cube. Length into breadth into height. Each of the
Counsel, are you
dimension.
disputing the injury?
Yeah, I'm disputing the injury, my lordship.
So
He
according
made
to
a.
she's not injured. She was taken to the hospital just for breakfast.
No, my lordship, she was injured. But the other thing is, if the injury is in a contradiction, then the medical certificate.
Yeah, I heard you. Yep.
My lordship, witness.
Yes. Your time is up.
No, not even for witnesses, because I didn't conduct even a single witness yet.
Your time management was.
I was I had suggested I wanted to conduct a few witnesses over there, but there were some questions because of which it got elongated. Anyway, my apologies.
All right.
As you exceeded the time limit, we cannot allow for witness prosecution because we are behind the schedule. We are done with the proceedings right now, with the permission of the bench for both of the parties.
Yes, you can proceed.
Yes.
Next team.
Obliged, your ladyship lordship.
Much obliged, my ladyship lordship.
Much obliged. Much obliged.
So with the permission of the bench, we will take an half an hour lunch break right now.
All right.
कुछ भाई ऐसे होते हैं ना जो कुछ भाई ऐसे होते हैं ना जो बहनों के साथ ऐसे रहते हैं, कोई शादी होने के बाद बीवी को पल्लू पकड़ के बैठती है, वो तू है।
बीवी नहीं इधर
आ जाएगी
आएगी, किसी इंतजार कर रही। बीवी का पल्लू पकड़ना गलत नहीं है, अगर जब बीवी को गलत कर रही है तो गलत बताना
ऐसे। But at least no, at least वहाँ पे AC है।
चालू
बहुत गर्म। नहीं AC वाला।
क्लिक करके दिखा
Guys, please rename yourself as your team name. Guys, please rename yourself as your team name and rejoin. People have their names displayed. Please rename yourself as your team code on Zoom.
Hello? VM3 researcher and rename to the VM3 researcher.
Okay.
Am I? Are we audible?
Raju, I'm busy in the mood competition.
We will begin with the proceedings. The prosecution begin
Hello, sir. We are audible.
with the proceedings with the permission of the bench.
Are we audible, sir?
We will be.
Sir, are we audible?
Yes, yes.
Okay, thank you, ma'am.
May I submit, Your Honor? I, Madhura Jagtap, Council number 1, and Anurag Jain, Council number 2, we are representing the side of prosecution. I would like to start with my case. Accused 1 and accused 2. Accused 1 is Sara. She is belong to the minority community living in a village, Udyam Nagar, Asta. She is working as Shiksha Mitra. She has a postgraduate degree in personality development and psychology. She is in love affair with accused 2, that is Aras, and accused 2 belong to the lower community, that is Sunni community. Accused 2, Aras, is dropout 6 dropout working as a wood sawing unit, and his wood sawing unit is in the vicinity of accused 1. May I lordship please refer to the page number 8 and I'm starting with the arguments. The accused 1 and accused 2 is facing a trial for a crime punishable under section 302 right with section 34 of IPC. Section 302 is punishment for murder of IPC, and IPC section 34 is a common intention. The FIR number 182/20 dated on 15th April 2020 lodged under Udyam Nagar police station against by the complainant filed by the informant Lala Khan. The charges of offence punishable under the section 302 and 34 of IPC has been framed against the accused 1 and accused 2, which they both have denied and claimed to be filed. Your Lordship, many witnesses and evidence are supported to our case to bring the guilt of the accused to the home. The witnesses list are examined as follow at point number 3, page 8. Your Lordship, we has also relied upon the documentary evidence as under, which is given in the point 4 at page number 8. Accused 1 and accused 2 have a common intention to commit the said offence because both were in love affair. Knows that Sarah's family will not accept their relationship, and knowing that Sarah is 2 months pregnant will further complicate the matter, which might resulted into the abortion and honoring of killing of Sarah and Aras. So to save oneself, they both have made a plan to kill all the family members, and Sarah, accused 1 and accused 2, then occupy the property and live happily together. Accused 2, Aras, is 6th dropout and with no good income, somehow had convinced Sarah and have carried out an affair with her. Knowing that once she is in love with him, he can further convince Sarah in how they both can have the property for themselves and can live happily together. It's very common and understood that since both Sarah, the accused 1, and Aras, the accused 2, made the plan and executed the same, hence all the family members are dead, but Sarah is all safe. Sarah's story, the accused 1's story, to the police station at the time of investigation is also contradictory. As Sarah, accused 1, says that the robbers attacked her house, but there is no sign of such struggle that robbers would have faced in entering the house. If robbers came with the intention of the robbery, then what all things are robbed and even not declared or mentioned, which knows that Sarah's story is just made up. Further, I will say counsel number 2 to further say.
My Lordship, in furtherance to the case which has been put by prosecution, I would like to throw light on certain points that while with the recovery and investigation with the police, it was they have obtained recovery materials which is weapon material, which is X, and a blood-stained shirt were made out from Aras. There were further equipments which were also traced out by police, which was like Nokia mobile phone, empty strip of 10 tablets, blood-stained clothes, and the mobile SIM of Aras was taken from Sarah's possession. Which later on further investigation with police, both the accusers, they have accepted and they have denied the situations and the claims over them, and they have in fact put the blames on each other, which actually shows that yes, they have been trying to safeguard themselves, but there had been a common motive behind them, which my colleague has already explained earlier, that they have been in a love affair, and to safeguard themselves from honor killing for their abortion of their kid, which could happen, and to live together with a happy life, which they have thought over. They had this common intentions and motive by which they framed the entire plan, and they have executed it, killing their entire family members. With this, there had been certain supporting evidences also, which is by the testimonies of the pharmacist Bilal Ahmed and Bhanu Pratap, the block leader, and who have heard Aras' friend buying about certain sleeping pills, which are suspected that have been used to take over for killing of this or sedating the people, and then giving a result to their plan. There is a testimony from the pawn shop owner also that he has heard about it. Similarly, there is a testimony which is also put forward by the local pharmacist, who said he has denied Aras earlier from buying sleeping pills, which actually says that yes, since Aras did not succeed in buying sleeping pills, he would have
5 minutes left.
He would have tried from taking it from some of his friend, and would have taken this sleeping pills and would have further executed their plan. So depending upon all this material relied, we understand that police has done their job in taking the witness and taking the evidences in their custody, and they have further framed the case and put it forward. The prosecution has made out prima facie in his favor, and the balance of the conveyance is actually favoring the situation, which is for the prosecution to submit that it would be a great loss to the society if this kind of a heinous crime which has been left out open and people are not proven guilty and given sentences, or probably they are convicted. The offense committed by both the accused person comes under the category of rarest of the rare crimes, and which are been taken under the punishable offense of capital sentence, which has been actually taken from the reference of Bachchan Singh versus State of Punjab case, which limits the vast discretion of the court in imposing death penalties. The prosecution has also further relied upon the citations, which is from Manipal Nath versus the State of Assam and
I
Bachchan
would
of
like to
State
stop
of.
you over here that whatever evidences that you are presenting before the court are all hearsay evidences. So how will you justify your case only on the basis of hearsay evidences? The person who has been hearing, the friend, and the XYZ theory, everything is a hearsay evidence. But where does the actual evidence lie in all these things?
Lordship, the evidence which have been is yes, which you have rightly mentioned, but it actually also proves about the common motive and intention of both the people, both the accusers, who have been actually trying to frame out a good life by killing out all the members, occupying the property of the house.
Counsel,
There is
but
no
the
evidence to
theory.
support that.
Yeah,
Yeah,
so
the counsel
we have our
that
witnesses. We have our witnesses to prove our points.
Let's first examine the witness and then you can point out from evidence what is there to support your case.
Surely. So with your,
Otherwise, it becomes just a narration.
absolutely, sir. So with your permission, we would like to call our first witness, Mr. Lala Khan.
Yes.
Witness Sara Khan.
Lala.
Lala Khan.
Mr. Khan.
Hello.
Hello. Mr. Khan.
Yeah, am I audible?
Yes, you are. Can you please tell your name to the court?
Lala Khan.
What is your age?
42.
Mr. Lala Khan, where do you reside?
Udhamnagar.
Is it in the same locality where Sarah lives?
Yes, yes. We are neighbor.
Okay. So being neighbor, you would be knowing good about the Sarah's families and their regular activities?
Not that much because we are new in that locality.
Okay. But in the meanwhile, have you ever come across any fights or quarrel that has happened between Sarah and...
Direct question, not allowed.
You lead to that question, counsel. You're directly asking him.
You can't
I'm
lead
sorry.
the witness.
I'm sorry, let me reframe it. Have you come across any uncommon thing while living?
No, again, it's the same thing. Putting in a different ways.
Do you have come across any fights in the locality?
Counsel, I'm repeating again and again, you can't lead the witness.
Fair. So if I can understand, Mr. Lala Khan, that on the alleged night, what were you doing? If you could just explain what has happened on that night.
What's happening?
Hello.
Yeah.
Yeah, I was walking outside of my home after dinner.
Okay. And were you what made you reach to the house?
Yes, not stated so, Mr. Counsel.
So while you were walking across, did you notice anything unsuspicious?
You mean suspicious?
Yeah, I'm sorry, suspicious. Mr. Lala Khan, as in your statement,
you can't confront the witness with a statement, Mr.
Sure.
Let him depose.
I'm sorry, sir. I am not able to hear Mr. Lala Khan, sir.
Lala Khan is not audible, I guess.
Hello.
Yeah, Mr. Lala Khan, can you hear us?
Yes, yes.
Yeah. So you were walking along the locality. Then further, what happened?
I heard some noise coming out from my neighborhood, so I felt something was wrong. So I went to see that.
So when you say neighborhood, whose house it was?
At first, I ignored that because I thought that was normal family argument. But while I was returning to my house, then I heard the same voice again. Then I checked that that voice was coming from Sarah's house. So I went there, and as I reached there, I saw Sarah's father and mother was dead.
How did you reach to their house? Through the door or through terrace or through windows? Which place? How did you enter their house?
Through main door.
Which was kept open?
Yes, yes.
Okay. What did you, after entering the house, what did you notice there?
Both were slaughtered by Nick, and the blood was flowing.
Okay. Anything unusual in like which could relate there is any robbery or something like such which you noticed?
Actually, by seeing that, I was in stress.
You was in stress. Okay, so you didn't notice over it.
I haven't seen that before. That's why.
Okay. Apart from this two bodies which you mentioned, did you notice anything else even?
Sorry, couldn't hear you.
Apart from these two bodies, did you even notice anything else?
Yeah, in the adjacent room, 3 more dead bodies were discovered by me.
Okay.
And they were Sarah's brother and sister-in-law and their child.
Okay. By any chance, do you know how many rooms that place has?
If I'm not wrong, then there were 2 rooms.
Okay. So in one room you have noticed 2 dead bodies, and in the second room you have noticed 3 dead bodies.
Yes, yes.
Okay. Do you find anybody out there who is into unconscious state or something, anything like such, or somebody who needed help?
No. When I entered,
Counsel, you're leading him unconscious.
I'm
You
sorry,
never mentioned about anyone being unconscious.
My point was only to find out if he has noticed anybody else out there.
He has already deposed about it. We are warning the court is warning you again and again.
Sure, sir. So have you also heard about Aras? The second
Again, your leading question. The witness has not stated about Aras anything.
Okay.
You cannot identify him to Aras to this witness directly. If he knows, he will voluntarily state it.
Surely, ma'am. I apologize for it. So after you have seen all these bodies and bloodsheds, what you have done next?
Actually, in the same room.
5 minutes left.
In the same room where I found those 3 dead bodies, Sarah's brother and sister-in-law and their child. In that room, Razia was also there, but she was alive and she was breathing, and she was unconscious. So I took her to the hospital.
Okay, so you were the one who took up Razia to the hospital, and then what you did?
Before taking her to the hospital, I have raised an alarm so that everyone should know about the fact that this incident has been happened in our locality.
Okay, and then you moved out to hospital along with Razia.
Yes, yes.
Sure. My lord, from this all witness statement, what I want to prove it across that there had been some instance which has happened, whereas the complainant has put across that there has been dead bodies which he has found. When he entered the room, it was open, and he has found only 2 rooms in that house. Further to that, the main accused was not found in the room anywhere or in the house anywhere. That is what my point is. I want to put it forward. That second point which I want to put forward is the complainant has not seen about any robbery instances because he failed to notice that.
In fact, that demolishes your case that Sarah was found at that place. This witness has not stated anything, and in fact, you are confronted with, in spite of your confrontation, the witness is silent on the issue that Sarah was there. In 2 rooms, all that he could see is only 3 bodies in one room, 2 bodies in another room. That's all.
Secondly, I will bring to your notice, counsel, this one main point that your witness voluntarily stated that while going for a walk, while going on his way, he also heard someone quarreling in the house of Sarah, and while coming also he heard the same voice. So it was not the theory of sedation and everything, but it was some kind of quarrel which your witness is stating. So the theory of someone being sedating, some person sedating the family members is totally ruled out over here.
Contradicting your own theory.
Yes.
So
Your counsel, Your Honor, can I call another witness, Razia?
Second thing, don't you think it is important that once you are taking this witness in the witness box, you need to prove that FIR was registered, complaint was registered?
yes, we
At
do
the
that.
instance of Lala Khan?
Yeah, we do that, sir.
All right, next witness.
May I now ask question to Razia?
Yes, please.
Yes.
Name? Razia, are we audible? Are we audible?
She's not able to hear you.
Are we audible?
Wait a
Hello?
second. We are sorting out the connection.
Okay.
Can we call another witness?
If she's...
If Razia is having an issue with the...
Yes, yes, I'm audible.
Okay. Name?
Razia,
Age?
12 years old.
Are you working as a caretaker of Nal?
Yes.
Are you working at the accused one house?
No, I was called.
What do you know about Sarah's nature?
Not exactly Sarah's nature.
2 minutes left.
You cannot call for an opinion of the witness. Not permissible.
Your Honor. Have you witnessed the fight at home?
Come on,
Yeah.
this is again leading question.
Sorry, Your Honor. Did Sarah made tea for herself and drank?
Again a
Yes.
leading question. Why are you telling her what she made?
Sorry, Your Honor.
The question which is suggestive itself is disallowed.
How is the environment at home?
Again, opinion.
Sorry, Your Honor.
What happened then?
What happened that night?
Which night?
The incident night. What happened? Am I audible, Razia?
We had tea that night and then I went to my bedroom to sleep.
Who made that tea?
I don't recall.
1 minute left.
Did you see Sarah as violent in the fight? Or have you...
Yes.
She has not stated about any fight, counsel.
How was the environment at the home, or how are the family members with you?
Normal.
Have they taken care of you?
Yes.
What is the relevancy of this question?
Because from that we can come to know about the family members' approach to the unknown person, and how is the approach with the Sarah accused.
Counsel, that is irrelevant to this case. That's not at all relevant.
Counsel.
You can come to directly to the point.
Counsel, I'll just ask you one question. What is the age of your witness that you mentioned?
12 years old.
12 years, right?
Yes, Your Honor.
How would you justify the credentiality of this statements as of now?
She is a minor. So,
Time up for witness.
She's an eyewitness, ma'am.
That is not a case of prosecution that she is an eyewitness.
Everyone is eyewitness.
Fair. We leave it open to defense in that case.
All right. So you want defense to lead with the prosecution case?
Probably not to lead with the case, but then we would like to hear from defense and counter and prove our witnesses and points.
All right. We'll check that.
Respondents to proceed with their submissions to the court with the permission of the bench. I would like the respondents to proceed with their submissions to the bench. Am I audible? Hello? Huh? Hello? Hello?
Yes, you're audible.
Yes, I would like the defendants to submit their submissions before the bench.
We are not able to hear the respondents, sir.
Respondent are not audible.
Can we, respondents, are you there? Please unmute yourself. Respondents. Team VM7, are you not gonna respond?
Can you hear my voice?
Yes, now you're audible.
Okay. There is some issues. Okay. Can I start now?
Yes, please proceed.
Okay. I, Kunal Sunil Jadhav, legal counsel appearing on behalf of my client, the accused in the case, and this is my colleague Jyoti Ramchandra Yadav. Jyoti? Yes, you may speak.
Yes, counsel, proceed. Yes, counsel.
PM second, your mic is it's again mute, I suppose.
Hello. Hello. Ma'am, I'm audible now? Hello.
Hello, yes, ma'am, you are audible.
Thank you. Sir, I am Jyoti Ramsundar Yadav. I am a legal counsel appearing on my behalf client Sara. Sara, the accused in the case. I am the legal counsel number 2 in the matter.
So you are only representing Sara?
Yes.
All right. Yes, counsel, proceed, please.
Further, Kunal, proceed further.
Okay. Actually, there is some issues in network. Okay. So, shall I proceed the case, sir?
Yes, Kunal.
Hello. Okay. As per the prosecution has said regarding all the facts and issues in that case, the Sarah and Dara both are belong to the minority family, and because of his love and affection, both are not in intention to do this crime. As the scenario has been created over here, that they are having the love and affection, and the Sarah family is always having the opposed to the Araz and Sarah relation. There is no any concrete evidence in this case to show that both are commonly intention to do this act. As per the case, means Lala Khan has informed to the police station at around 11:45 when the already incident has been happened, and that police has been registered the diary at 3:45. Within a 1 hour, it will take the 1 hours to police to return the statements. And when the police will be arrived at that place, the Sarah is already in that place. He has not left the house, and that police, because of his given the statement regarding that how the Aras will be entered in his suspicious story, police has just arrested him because at that time Sarah is not in a position to give the proper statement before the police because his all family members has been died at that time. So on that basis of this statement, when he will be in a mental depression, it will not be counted. And when all the witnesses statement and that witness statement and neighbor statement, it will not shows that both are liable for this crime.
Both are liable.
Both are not liable for that.
See, let's come directly to the point. The case of the prosecution is that there is a recovery at your instance, at the instance of both the accused, about weapon used in the crime, and at the same time, the incriminating material is like blood-stained clothes and pillow covers, everything recovered at the instance of Sarah. So tell me what explanation you have for that, and why the Sarah is present at that particular scene of offense. Why an adverse inference should not be drawn against Sarah?
As per the witnesses stated by the Bilal Ahmed, Rajesh Lugade, which has already given the statement in the police station regarding that how the Sarah Aras has been taken the steps, fell steps, and how the Aras and his friends take the speaking regarding the how to do the crime. It will not show that in that his statement they have not mentioned the name of the Sarah. So Sarah is not directly come into the picture. Because of the love and affection between the Aras and Sarah, they are both are liable for this showing in this case, liable for this crime.
Oh, what about the recovery? I'm asking you. At the instance under Section 27 of Evidence Act, the recovery at the instance of both the accused. One accused has given recovery.
Also, the call records which right on the day of the incident, the call records also showing that they were in constant communication with each other.
Okay, but in the call record, they have not speak regarding the how they will do the crime. Is there?
Yeah, but even you don't know what they spoke in the call record. Then you know what they have spoken in the call records.
No. It is unclear. It is unclear before the court of law. That's why I'm speaking.
Exactly. So on the day of the incident, exchanging such n number of call records precisely shows that they had some planning at the back end.
There is no any written regarding if they are having the love and affection, means they are having the same intention to do the crime.
That also does not deny the thing because Sarah was 2 months pregnant when this incident took place. So 2 months prior to the incident, they knew that this kind of offense or this kind of thing which has taken place, if it comes out in public, it would be a great sense of mockery for them. And they will have to face the society at large. That is the reason they took this step. Can't this theory be negated?
It cannot be neglected, but Sarah has well educated.
Once you admit that, one, it cannot be negated, that but has no meaning. And secondly, tell me what you have to say about that admission given by accused. What is your answer to that?
Admission given by the accused
to the crime. Sarah says it's committed by Aras. Aras says it's committed by Sarah. At the instance of Sarah, she requested me to come. I came there. So what explanation you have to advance before the court about it?
The statement given by the both at the police station, it is not admissible in the court of law, sir.
Why?
Because of pressure from the police station, they have given this statement.
Tell me the provision. Tell me the law. Under which provision? And what law prevents that? Sorry? Yes, Mr. Zadav, you are not audible. I will like second counsel to address that because Mr. Zadav is not audible.
Hello.
Yes, Miss Yadav, please address the court on the court's query.
Yes, sir. What query?
5 minutes left.
Why this admission is not admissible? Under which provision of the law?
Right.
Not.
None. The statement given before the court will be admissible at court, not before the given statement in the police station.
That you have already stated, but why? I am asking you, under which provision it is prohibited, that it cannot be looked into?
Sorry, sir. I don't have.
Okay. Yeah, proceed.
Okay.
Do you have any other witnesses to cross-examine?
I would like to cross-examine Sir Rajesh Lugadi, the local pharmacist.
Please call your witness.
Will be there.
Shall I call to the
Yeah,
Rajesh
please
Lugadi?
do that. Please proceed.
Hello.
Hello.
Yes, am I audible now?
Yes, Rajesh.
Yes, sir.
Please give your self-introduction to the court.
My name is Rajesh Lugade and I'm a pharmacist.
Defense, you are cross-examining him. Don't need to ask an introduction and all. Come directly to the point.
Hello.
Yes.
Rajesh, give the statement as you have already given to the police stations.
Mr. Zadav is under cross-examination. You are conducting cross, not examination chief.
Okay.
There is a difference between chief and cross. Like I said, are you leading the prosecution?
Counsel, bring your questions directly as a cross-examination to him and ask the question. We don't want the peripheral theory now.
In the cross-examination, you are supposed to check the credibility of the witness, not prove the credibility. Okay? Directly put a question. Don't waste time. You have very limited time. Mr. Kunal, are you there? Yeah, Miss Yadav, are you there?
Yes, I'm there.
Respondents, are you able to hear the judges or the bench? Or are you having connection issues? Respondents, VM7, are you able to hear VM7?
Hello?
Yes. The bench is
I
addressing you.
I want to cross-examination Mr. Bilal. Cross-examine Mr. Bilal.
Yeah, please proceed.
Yes, please proceed.
Mr. Bilal. Hello.
Hello.
Hello, Mr. Bilal. Ahmed. Yes. I just want to ask one question. Have you heard the name of Sarah? Any conversation when you going to heard of Ahmed with friend? Sorry, Ara's friend.
No, I just heard the Salim's name in a conversation.
Okay, thank you.
In his statement also, he has never named Sarah, madam. That is not even the case of the prosecution. Anyways, any other witness?
And the
No, sir, no.
You want to conclude your statement? Counsel, do you have any prayer to make to the court?
Sir, if defense is not looking, we would like to put our rebuttal there.
Yes, prosecution, please.
With your permission, sir, with all the facts which has been there in the case, with the witnesses and the other stories which has been proved here, along with the reports, we would like to put in that it has a common intentions and motive for both of these
I'm sorry,
accused.
counsel, what you have proved in evidence? Can you elaborate the court? What
So,
you have proved in the evidence?
So
When
there
the
had been
witness has stepped in the witness box. I'm not talking about the statement which is recorded by the police.
Absolutely, sir. I understand that during this discussion we failed to do that, but with the court details which has been there, there has been lot of other evidences which has been taken, weapons and all which has been obtained from both the accused.
But those are all corroborative piece of material. Those are not substantive evidence. There is a difference between substantive evidence and corroboration.
We understand that, sir, but due to time frame issues, probably we were not able to put it forward here right now.
All right, sir.
Yeah, and we take up that because of the common intention and motive between accused 1 and 2, who has thought of having a good life living together, giving a birth to their child, and taking over the property of that is belonging to the family, they have planned for this cold-blooded murder and have executed it well. And to looking into this heinous crime, we actually prayed forward that the accused 1 and 2 should be penalized with capital punishment, and we rest our case here.
It's a good material for a Bollywood film. All right. Thank you.
Thank you, sir.
Thank you.
With the permission of the bench, may I interrupt?
Yes, please.
Yes. As we are done with the proceedings, we will be proceeding to the next teams in 2 minutes.
Yeah, please.
4:45.
क्यों पीछे पड़ा है कैसे
With the permission of the are present at the current state, we will proceed. The bench present at the time. Hello. Hello.
So it is VM5 and VM19.
Applicant. I would like the applicants to begin with their proceedings with the permission of the bench.
Yeah, please proceed.
Thank you. My privilege. I, the counsel on behalf of prosecution in the case State of Asta versus Sara and Araz, seeks permission from the Honorable Court for the opening statement.
Yeah, please.
The Honorable Court has jurisdiction to try the instant matter under Section 177, read with Section 209 of CRPC. Prosecution submits that the accused number 1, Sara, and accused number 2, Araz, aged in their early 20s, residing at Uddam Nagar, are accused of murdering Sara's family, that is, her mother, her father, brother, sister-in-law, and their 10-month-old child. The accused number 1 would be the ultimate legal heir after the commission of offense. Also, her relationship with accused number 2 was not accepted in the family. Prosecution relies on credible witnesses, account of statement of Lala, the first to reach at the crime scene, Razia, the sole survivor and victim of the scene. Medical witnesses Dr. Karnik and Dr. Shashank further prove the commitment of the crime. Prosecution also relies on documentary evidences like medical report and post-mortem report. Prosecution will request Honorable Court to appreciate the important piece of evidence, that is, the murder weapon axe, is recovered by police on the information given by the accused. Prosecution will also rely on Section 300 IPC, various judgments of High Court and Supreme Court, to prove beyond any reasonable doubt that accused is guilty of murder and should be dealt with the severest punishment under Section 302 of Indian Penal Code. With the permission of the bench, can I further move on to the issues of the case?
Yes.
Before you move on further, just like to ask one question. Under which section you are making this opening of statement?
Sorry?
Under which provision of law you are opening your case?
I'm
All right, you can proceed.
Yeah, thank you. Much obliged, my lord. Coming towards the issues of the case, the circumstantial evidence along with the facts and evidence on record conclusively established that there was a common intention in committing the crime of murder. The petitioner humbly submits that the facts and evidence on record conclusively established that there was a common intention in committing the crime. The accused were lovers and wanted to marry, which was opposed by the family members of respondent number 1. Respondents were in an illicit physical relationship due to which respondent number 1 got pregnant. Both of them planned to eliminate the whole family, knowing very well that in doing so, they will become the only legal heir of the property. The mens rea of the respondent is well proven. The respondent had chalked out plan to kill the whole family to claim the property and get married. So there should be no obstruction from anybody and live peacefully. This was the main reason that they fully planned out and carry out their common intention. Also, there were no signs of forced entry and robbery as stated by accused number 1. I would further request I would further pass on the my co-counsel to continue with the contentions with the bench's permission.
Yeah, please.
Much obliged.
I, the co-counsel, behalf of the prosecution, seeks permission from the honorable bench to elaborate and explain the further issues raised. May I?
Yes. Please, counsel.
Much obliged. As my co-counsel explained the facts of the case, I would further say the issues which are raised that goes like, do the facts of the case and evidence in record conclusively lead to the inference that the criminal conspiracy is hatched? As the counsel behalf of the applicant say yes, as the post-mortem reports have indicated the cause of death of the deceased people due to ante-mortem injuries caused by a sharp-edged weapon and a cut on the neck. Furthermore, as per the fact sheet, before the murder took place, the applicant submits that Rajesh Lugade has stated that on the morning of 14th April, respondent 2, that is Aras, had attempted to purchase sleeping pills. And on the same morning, Salim, which is respondent's 2 friend, was successful in buying the sleeping pills from the same local pharmacy. As per the testimony of Mr. Bhanu Pratap, who is the block head of the village, and Mr. Bilal Ahmed, who is the owner of the pan shop, to the IO. The post-mortem reports also indicates the presence of the drug in the stomach of the deceased, and that such presence of the drug clearly establishes an administration way before the commitment of the crime. Now, the drugs which were used to sedate the family members could have been administered only by the person who had frequent access in and out of the house, and the consummation of such drug could be either done by the individual's choice or from a person who you trust. Therefore, looking at the facts, the only possible suspect who could have administered the sedation is respondent 1, that is Sarah. The another issue which is raised is, do the facts and evidence on record clearly establish that the statements given by the respondents have been made on fictional basis in order to mislead the court and escape the conviction? The applicant humbly submits the respondent 1 and 2, that is Sarah and Aras, have acted collaboratively as both of
5
them
minutes
were in
left.
an... Apologies. Okay, may I continue?
Please.
Yes, much obliged. Both of them were in an illicit relationship which was not acceptable to their family members. Also, respondent 1 and 2 were pregnant, and since respondent 2 was class 6 dropout, and he worked in a wood sawing unit, which made it difficult for them to survive on a maigre salary that respondent 2 received. So in order to meet their ends, they planned to conspire and kill family members of respondent 1 and become the only legal heir of the property acquired. This establishes
I would just like to stop you here. Why would they only conspire to kill them? They could have robbed the house and just flew away. Why then kill all these people and then get off all these traumatic situations? They would have just robbed the house and gone away with each other. No? The entire theory that you're building upon could have been this way also. Why murder only then?
Very valid, my ladyship, but there were in acceptance of this illicit relationship, and hence
they could have left this town, they could have left the village and gone away somewhere else.
The accused did not really were in the state of leaving the town and did not have enough money to make their lifestyle or living out of the town, and maybe that conspired them to kill their family.
Where do you get that?
Apologies, sir.
Where do you get that? Where is the material to say that they didn't have enough money?
As the respondent 2 was class 6 dropout.
Yeah, that is what I said.
But as far as the qualification of accused number 1 is concerned, she was highly qualified.
Yeah,
but she was a Shiksha Mitra teacher in a government school.
Exactly.
Yeah.
Can you say by looking into the qualification that it was, they were not having any proper source, or they could not have earned their livelihood? Looking at the qualification of accused number 1, I don't feel so.
My lord, very valid, but the property here also comes at a curveball.
See, either you take illicit relationship as a motive or a property angle.
So validation of relationship as well as the property here.
Counsel, that's what I said, na. They could have robbed the house, they could have robbed Sarah's house, and they could have left the place. It was easy work for them. Why build all this entire theory of taking pills, murdering them, making tea, everything XYZ?
Correct.
So much of homework to do.
My ladyship, my lord, my ladyship, the robbed money couldn't have been for a long term, but the property, they could have invested in real estate. They could have got money from it. So a happy relationship is always comes along with a validation and as also with the property. And hence their motive was to kill their family.
That is what you think, right?
What do you think?
That's what the circumstantial evidence completes the conspiracy and chain.
No. Now we are specifically talking about what is the thought process. The thought process of man varies from person to person. Now, what you think?
My lordship, my ladyship, if they wouldn't have killed their family, the respondent's one family, there was a 10-month-old kid named Nanal who was also killed. If they would have just robbed the money and went in another town, maybe the property, the legal hire of the property would have been null and they wouldn't have got anything out of it.
No, counsel, how come that small child could have been the legal heir? She was the daughter of the house.
For the future, my ladyship, for the future, when the respondent's one family would have died.
I will just put two questions to you. First of all, she was the daughter of the house, right? And this Nal was a nephew. It was her nephew.
Yes.
So who has the first take on the property?
But my ladyship, if she would have ran with Aras.
I will put you one more question. Would you justify the theory which you're talking about now if Aras would have been of an upper caste and would have been rich?
But if the Aras would have been of upper caste, there would have been no opposition.
That is what I'm saying. Your entire theory is based on the caste and his financial background?
Maybe. Partially, ma'am.
Partially,
maybe or partially.
Your contention
partially, my lordship.
Your contention will be taken partially then.
So that means you are not sure about your contentions.
You are partially putting forward your prosecution case.
That is not, I would agree with, honorable bench.
Take one stand, counsel.
You are not there to agree with the bench.
Yes.
We don't need your agreement.
My ladyship, my lordship, I would ask for the permission to examine the witnesses and hence I can prove this point.
Go forward, yes.
Much obliged. So I would call upon the witness, Dr. Karnik.
Please.
Is Dr. Karnik here?
Sir, we are having issues with Dr. Karnik's connection and we would like the prosecution to move.
He's there.
Can you hear me?
He's there.
Yes, Dr. Karnik. Are we audible to you?
Yes.
So Dr. Karnik, what is your qualification?
I'm a Jodi of BGM Hospital, Udhamnagar.
Okay. You examined the patient named Razia. Is that correct?
Yes.
Is this report made by you?
Yes, I've made this report and I've sent this report to the investigating officer.
Valid. So Dr. Karnik, what was the nature of the wound?
Sorry, I can't hear you. Can you repeat?
What was the nature of the wound?
Ma'am, your voice is again breaking.
Dr. Karnik, I'm asking what was the nature of the wound that Razia had?
Actually, the wound was 4 centimeters. It was a 4 centimeter cut on the throat and it was dangerous for
So Dr. Karnik,
the destiny was with her and she survived.
Okay. So Dr. Karnik, do you agree with your own specialist opinion that it was caused by a sharp-edged object?
I can't understand.
It is already there
Due
on
to
the
breaking of
certificate.
voice, I can't understand your question.
Dr. Karnik, do you agree that the wound was caused by a sharp edge object?
He has already opined that in an injury certificate. We will look into it.
Much obliged, my lordship. Also, I would like to call the next witness, who is Rajesh Lugade, the local pharmacist.
Yeah, please.
Much obliged, sir. Mr. Lugade?
Am I audible now?
Yes, you are audible. Are we audible to you?
Yeah, you're audible.
Yeah. So, Mr. Lugade, on the fateful morning of 14th April, did Aras visit your pharmacy?
Beg your pardon, I couldn't hear you properly.
On the fateful morning of 14th April, did Aras visit your pharmacy?
Yes, he did visit, but I don't remember he visited on that particular date only, but he has visited my shop multiple times.
Okay. Did Aras
I
ever
don't
come
remember
to
he
you?
visited on a specific date that you're talking about.
Okay. Do you recall if Aras ever came to your pharmacy to buy sleeping pills?
Yes.
Okay.
That is again
Yes,
question.
he is a very frequent visitor of my shop. He frequently comes to my shop, but on a particular day he came for purchasing sleeping pills, but he was not having a
Counsel, you
proper
cannot
prescription.
ask that directly to the witness.
That was a leading question.
Apologies, my honorable bench.
We are not taking that answer on record.
Oh.
Any further questions?
Hello.
Yeah, Mr. Lugade.
Hello.
Hello.
Yeah, the voice is coming. Yes. You can speak.
Yeah, that's it for now. With the permission of honorable bench, I would like to let my co-counsel examine the other witnesses.
Yeah, please.
Much obliged.
With the permission of the bench, I would like to chief examine Lala Khan first.
Please proceed.
Lala Khan. Are you there, Lala Khan?
Yes.
What were you doing on the night of 14th April?
Sorry?
What were you doing on the night of 14th of April, 2020?
I was having my dinner. After that, I went out for a walk.
And the connecting incidences?
While walking, I heard some noise coming out from my neighborhood, but I ignored that because I thought that was some normal family argument. But while returning back to my home, I heard that voice again. So I felt something was wrong. So I went to check that.
Okay. So where did you went to check it?
I heard that voice coming from Sarah's house because while going, I heard some voice, but I don't know from where that
You
voice
heard
was
it from
coming.
Sarah's house. So what did you do next?
I went there, and as I saw, the door was open. So I directly entered the house, and I saw Sarah's father and mother was lying on the floor with slaughtered neck.
Okay. That's it, Lala Khan. My lord, I would like to prove that the door was open. Thus, there is no struggle, no sign of struggle entry by any robbers. And the door was open. That itself shows that the door was kept open to welcome the accused.
That doesn't mean that door was open before incident. He has not proved that.
My lord, there is no one left to open the door after the incident.
No, but why will someone keep the door open and then do the crime?
Exactly. And when Lala Khan, by the time Lala Khan entered the room, the door was already open.
Already open, yeah.
So that means after the crime,
So
the door was already open.
My lord, my lady, so therefore, if there was struggle to open the door, there would have been something, either a break of the lock, either a break of the hatch or anything. But there were
How
no
this
signs of.
witness is proving that? Tell the court. How this witness is proving that?
Because he himself said that the door was open.
Exactly.
And
We are also on the same point.
He never
Door
said
was
that.
open.
He said my lady.
It is just a statement, counsel, that the door was open. Simple terminology. He never spoke about anything more than that.
Exactly.
The statement ends there that the door was open. Full stop.
Yeah, but he was further stating about the condition of the house where he saw people lying, but there were no, according to the facts given,
He has not stated anything.
He didn't state it. He just stated
My lord,
only two
my
dead
lord, my
bodies.
lady,
You have stopped him. You have stopped him, counsel. It was
Yeah.
your submission that you have stopped him at 2 dead bodies only. So in the statement as of now, the only 2 dead bodies.
Absolutely. Being the complainant, the statement recorded on record, being the complainant, states that he just entered the house and there was no signs of struggle seen on the door. So therefore, it proves that this is done by an insider. The door was
He has not deposed anything before the court.
Yes,
You are not
counsel.
allowed the witness.
Go beyond the door also. There's everything in the there's nothing left on the door. The door doesn't depict the crime.
I would like to call upon, with the bench's permission, I would like to call upon the next witness, Razia.
Yes.
Counsel, is there any special provision under law to examine the minor witnesses?
Yes, my lord. Under section 1, just give me a minute. Under section 118 of Indian Evidence Act, regarding the testimony of a child witness, it says that it has to be accepted cautiously, and court should find some corroboration given by the statement given by the case Nirmal Kumar versus State of Punjab there. And also when eyewitnesses who were of tender age between 10 and 12 years of age stood satisfactorily to searching cross-examination, they cannot be disbelieved only because of minor contradiction in their evidence, which is further proved in state of Karnataka versus Maruti.
But
Case of
is she an
99.
eyewitness? Whether Razia is an eyewitness?
My lord, she is the sole survivor. She is the victim of the entire scene.
I am putting a specific question. Whether
How
she is an eyewitness?
How can counsel?
Yes, my lady.
No. First answer the question asked by the co-bench.
Whether she is an eyewitness to the incident. Why are you examining her?
She has been put up in the witness list, my lord, and being the sole survivor, the
just
crucial.
Because she's in the witness list, you are examining her, right?
Sorry, my lord, apologies. Can you please come again?
Why are you examining this witness? Is she an eyewitness?
My lord, she was an insider of the house, thus knowing crucial matters of the family, and thus to prove about the relationship of Sarah and Araz, we need to examine this witness.
So basically, on the point of relationship, you want to examine a minor witness, and do you think the court should believe that?
The crucial material of the family lies
Whether
with
that
this
age,
witness, my lord.
the tender age, is capable enough of understanding the relationships?
No, my lord, but the age is much
Anyways.
capable enough to understand the reason of fights happening in the family.
Yes, I will pass on to my sister judge. Please.
Yeah.
Yes, my lady.
Yeah, counsel, what I wanted to ask you is when you're examining Razia, you think she's an eyewitness to it?
No, my lady. She is a victim of the scenario.
Okay. So how can she depose anything about that particular incident?
She is the only sole survivor of the incident, my lady.
How is she going to prove the case of prosecution is?
But the whole theory is that they were sedated by giving some kind of tea, right?
Yes, my lady. But
So
yes.
How can she know about the incident then?
She may know about the person making the tea. She may know about the person serving the tea.
May,
yes.
My lord, my lady, that will only be confirmed after her chief examination.
Okay,
that is not how it happens, madam. Unless the prosecution is sure, prosecution should not bring any witness in the witness box.
Exactly. And secondly, if your theory is that Tara and Raz have committed the crime, then why only Razia was left to be alive?
Ma'am, looking at the material given to us, in fact, section 307, which is
क्वेश्चन तो
attempt
पूछा
to
नहीं,
murder,
मेरे नाम पे सब
307.
झगड़े कर रहे हैं.
There's someone unmuted. Sorry, ma'am. Sorry, my lady. According to section 307 of IPC, which asks for attempt to murder, this section would also be added into the.
Counsel, my question is, why was she left alive then? My question is not attempt to murder. What had happened or not? It is like if a small infant of 10 months old was also not left alive, then why was Razia left alive then?
My lady, I would like to submit on this point that she wasn't left, my lady. She survived the incident. She was the survivor of the incident.
You read Exhibit B. Have you read Exhibit B? Exhibit B.
Yes. Yes.
What is the size of the injury?
4 centimeter cut.
Exactly. Then why was she happily left with only 4 centimeter cut? And everyone else was so brutally killed. Why only 4 centimeter?
My lady, everyone else were also slit-throated. Unfortunately, we do not have the size of cuts here, but they were also slit-throated. So she managed to survive the size of the cut. She could have been dead. Maybe she could also have been dead if our first witness.
Comparatively, the neck size or the throat size of a 12 years old child compared to a person of 32, 35, 50, 52 age year person, which do you think is tender and more susceptible to death?
Absolutely, my lady. But
where does the theory sustain them?
But taking into consideration,
you are putting forward this thing that the throat of a 12 years old will sustain an injury of 4 centimeters, but the throat of a 52 years old or 35 years old person will not sustain a 4 centimeter injury.
My lady, taking into consideration your points, I agree to all your points, but my lady, Razia was not a family member.
She was a person, counsel. She was a person. I'm not talking about a family member. She was a person. I am talking about what will be the implications of an injury.
Okay. My lady, putting this
Counsel,
into
in fact, the co-counsel argued the fact that Razia could have been a legal heir. Now you are saying that she was not a family member.
My lord, there's a.
Anyways, let's proceed.
My lord, there's a misconception. My co-counsel said that Nal could have been the legal heir ahead and not Razia. Razia is a caretaker and thus not a family member. Putting into legal words, I do not mean she's not a person, but definitely she cannot be the legal heir ahead of the property. Thus, the execution on her was a less severe one. And we never know the size of cuts on the others who are the deceased of the scenario.
All right, anything else to add?
You think that those injuries were 3.5 centimeter and those inflicted on her was 4 centimeters?
Ma'am, my lady, it could have been more or it could have been less. But the execution.
Counsel, can a 12-year girl can be a caretaker?
5 minutes left.
Can you please repeat, my lord, my lady? Your voice wasn't clear.
Anyways, counsel, you can proceed. Your time constraint.
Okay, much obliged, much obliged. So, with your permission, can I call upon the victim Razia, or shall I move ahead with Dr. Shashank?
That is up to you to decide.
Okay, I would like to call upon Dr. Shashank.
Please.
Dr. Shashank? Dr. Shashank?
Yes.
Yes. Did you have a victim on the 15th of April?
Yes.
Okay, can you tell me that the report attached in this exhibit is the report prepared by you?
Yes.
Okay. Can you please elaborate on the examination report which you've given, your medical report?
Yes, I found 3 dead bodies and I postmortem of that. Vasan, Hina, and Nal.
Okay. And what were the reasons for their death?
There was a slit throat and asphyxia.
Okay. And you've also mentioned about some blue smellless liquid. Can you
Yes.
please elaborate on the point?
Yes, it's an outcome of a sleeping pills.
Okay. So sleeping pills were found in the stomach of Vasan and Hina is what your reports mean to say?
Yes.
He said outcome.
Apologies, my lord.
He said that was the outcome of sleeping pills.
Yeah.
Sleeping
So blue
pills were not
smellless
found in the
liquid,
stomach.
blue smellless liquid found in the stomach of Vasan and Hina are the outcome of the sleeping pills.
Correct.
Yes.
So that means they were sedated.
That means the body contained contents of sleeping pill. That doesn't mean they were sedated. That could have been voluntary taking of the sleeping pills also.
Okay, much obliged, my lady. I would further conclude this with my prayers. Okay, after considering all the facts of the case and the circumstantial evidence gathered through investigation, it is very well established that both the respondents 1 and 2 are guilty beyond any reasonable doubt. And for such a gruesome, cold-blooded murder and butchering family members, such type of incident shudders the conscience of the society, and also the accused are liable to the severest of the punishment. This deserves no mercy in this court of justice. I pray to my Lord and my Lady to give them the highest sentence. This kind of case falls under the rarest of the rare case category, inviting the death penalty.
Counsel, you are supposed to argue on the point how it is established.
Sorry, my lord?
You just argued saying that it is established.
The conclusion
But you
of
have
the...
not answered the query of the court that how it is established, because that is a job of prosecution to bring before the court that how the guilt is established.
My lord, as per the reports and as per the evidence found, as per the statements of the witnesses,
See, I'm not asking you to generalize your statement. Point out from the evidence that what would suggest that the guilt is established beyond reasonable doubt.
My lord, as the pharmacist Rajesh Lugade said, that Araz had attempted to buy sleeping pills from him on that fateful morning. Thus, it proves the intention of the accused number 2, the intention to kill the family members of accused number 1 just to prove his relation, just to get along with a successful relation. The accused number 2 also just.
But then counsel, you are
yes, my lady.
Yeah, counsel, but again, like I mentioned to your co-counsel also, you are just building a theory around the relationship, the financial situation, and their strata in the society, like the caste strata. I just like I mentioned to your co-counsel also, had it been he's been rich and XYZ, the other factors would have been changed. This theory wouldn't be the same in your situation in this statement then.
My lady, as stated by my co-counsel regarding the financial condition of the family and also regarding the motive behind their murder. Most of the crimes in this society happens due to the financial conditions in the family. Also, I would like to pass on with the bench's permission. I would like my co-counsel to continue with her contentions ahead on the motive of killing the family on financial basis.
Yes, please.
Much obliged, much obliged, honorable bench. So
Time
I
up.
want to,
Time up.
with the permission of honorable bench, may I have 2 minutes?
Yes, like one minute.
Much obliged. So as my co-counsel stated and examined the further witnesses, I would like to prove the point that after examining the prime witness, that is Lala Khan, that it is proved that there was no forced entry to the house. And after examining Dr. Shashank, it was proved that the family members were sedated. And the murder is proved by the past post-mortem reports.
Counsel, both the things are not being proved. That is your misconception. That is your preconceived notion that these things are being proved, not the forced entry or the free entry has been proved, nor that they were sedated or they took sedation. Is proved.
My ladyship, but as per the fact sheets as well, when the police investigators came, they found no signs to struggle of entry, and there was no forced entry henceforth.
Counsel, you are not supposed to look into the fact sheet. You are supposed to look into the evidence which is recorded in the presence of the court.
Apologies, my lordship.
Counsel, forced entry doesn't seem that the murder has taken place, huh? Post entry or free entry doesn't denote this thing that the murder has been committed by the accused over here. I want this question to be answered that why only this Azhar and Sarah?
Because honorable bench, Araz and Sarah had all the motives to kill the family for getting along with an unhappy life, and that is the main core reason I find, and that's why as per the fact sheet and even the other reports, it follows that both the accused have had a plan to execute the murder.
All right, counsel. Thank you.
Much obliged.
Yes, defense counsel. Defense counsel, you are not audible.
Audible now?
Yes, very much.
Yeah. Thank you, my lord. May it please your honor, my lord. Myself, Aarti Bhandari, my co-counsel, Ms. Chaitali Modak, and researcher, Mr. Melvin Almeida. We are presenting a side of accused number 1, Ms. Sarah, and accused number 2, Mr. Araz. Myself will argue for acquittal to accused number 1, and my co-counsel will argue for acquittal to accused number 2. Your honor, this is a case of impossible. The possible theories which prosecution can only lead to impossible results. The results are impossible. Now we are here today because accused number 1 and accused number 2 are wrongly suspect of the charges for common intention and murder of 5 members of accused own family. My lord, I emphasize here that both the accused are not guilty because it is simply impossible, my lord.
What is impossible, counsel?
Certainly, my lord, I would like to tell you that the fact is, accused are not guilty. The prosecution is trying to fabricate a story as the alleged incidents to safeguard investigation agency who have failed to investigate the ground of circumstances.
No, we are on the point that what is impossible.
Certainly, my lord, let me just go ahead. I will explain, and at the side, I will prove that. The submission of the fact is accused number 1 and accused number 2 are nowhere involved in the said crime. It has not been proved by the evidence. It has not been proved by the witnesses also.
Can you throw some light that what is that material the prosecution is trying to rely upon, and what is that material which you have to negate that material? Let's argue on that line.
Certainly, my lord. The prosecution had tried to prove that the witnesses, they have asked Mr. Lala Khan, and Mr. Lala Khan's evidence have already been negated because he said, first of all, there was a family arguments. He didn't say that there was any commotion, any screaming, any crying. He said there was family argument. While returning from the walk, again...
So you admit to the situation that there was an argument between the family?
There was an argument between the family, or there might be an argument which is supporting my client's theory that there was a robbers who were trying to rob the house. It might be a sound from that people, those gang. Not certainly only Araz and Sarah, accused number 1 and accused number 2. Secondly, the door opening theory. It was also not proved whether the door was pre-opened or post-open of the door. The prosecution has failed to prove that, and only on the circumstantial evidence, I don't think that means it is believed that we cannot consider this evidence as a rarest of the rare, and we cannot ask for a capital punishment.
No, we are not on capital punishment. That is a stage will come later.
Sir.
First,
okay, certainly. So I will go ahead with my submission here, with your permission.
Yes, please.
Okay. As accused number 1 already stated in her statement, the group of robbers have attacked her house and murdered her family members as she was sleeping at the other side of the house. The answer to the possibility theory of a prosecution, my submission, my lord, is accused number 1 is highly educated, as she is...
I'm sorry to interrupt. Can you please repeat what was that theory you are putting forward about robbers?
Certainly, I will go ahead again. The accused have already stated that group of robbers have attacked in her house and murdered her family, which is not being accepted by prosecution, right? But possibility theory of a prosecution is not possible because the accused number 1 is very highly educated. She is too mature to perform such an immoral incident.
I will ask you one question over here, just a moment. You are putting forward the theory of the house being robbed, right?
Mm-hmm.
Okay. Now, have you ever come up with the term called drawing inferences? You know this concept of drawing inferences?
Draw and inferences?
Yes, like 2 + 2 = 4. Simple as that. Okay.
Yes.
Answer this one question. 2 questions of mine. Now, when you say the theory of robbery, as per Exhibit B, what is the weapon used in the injury to Razia?
Yes. As per Exhibit B, it is X.
Okay, wait. As per it is X. Okay. Now, do you think that the robbers will come with a big axe to rob the house?
Yes. I can certainly say yes. I cannot say it is for murder, but yes, they can enter in with axe. Maybe
only one weapon.
break the doors.
Only one weapon?
The weapon is not, this is a murder weapon, is been said by prosecution, but that weapon is not from the crime side. It has not been taken
Okay, okay. Now one more question. Were there any other marks of the axe on any other part of the house?
We can certainly check on this with the evidences.
Okay, one more question. If the theory of robbery is put into picture, then as per Exhibit D, why were there contents of sleeping pills in the body of Vasan and Hina then?
Certainly, to answer this question of your ladyship, the sleeping pills or that blue smellless liquid, it is found in only 2 dead bodies. The other 2 victims, which are, means other 2 deceased we can say, have no sign of this. At least it is not mentioned in their death certificate. So this might be voluntarily taken also. We cannot consider this as a plan of murder. It is not proved by prosecution. May I go ahead, my ladyship?
Yes, yes.
Yes.
See, that was I was saying, that she is highly educated and actually mature enough to perform such a immoral incidents, because she knows that what will be the consequences after such a incidents. She was earning good, and it is irrelevant to say both the accused for their future life was greedy for monetary gain. We cannot say they were greedy for monetary gain because they were earning good. They have an option to run away, get married, settle themselves some other village or somewhere else and earn good over there. So that is not the question which is proving that they were doing it for a property or inheritance.
But counsel, evidence in picture, that is, I'm coming back again to this point. This axe was easily accessible to the accused number 2.
My ladyship, the axe is easily accessible. We can say only because of the occupation. Only because of the occupation, but we can say he was working there. That's why we can say this. But my submission is, somebody means not somebody, the accused, the actual accused, which has not been taken consider, the robbers might be from the known community, and they taking advantage of this fact that such kind of weapon is easily accessible to accused number 2, they have used it. And another the same submission of my lady, that the axe, whatever we are calling as a murder weapon, is not received from the crime site, and also there is no forensic report has been received yet. So we have to certainly wait for that, so we can certainly contradict that also.
But ultimately this X was recovered at the instance of accused only.
The X is recovered from the pond. And
at the instance of accused. Try to understand the difference.
The accused has submitted the statement that we had thrown the axe in the pond.
Exactly. And there is a corroborative piece of material by Panwala, who says that he has already heard about the conversation that the knife has been thrown in the pond, and rightly that recovery is also from the pond. That too at the instance of that completes the chain.
Exactly, and drawing one more inference that the empty strip of 10 tablets certainly shows that the 10 tablets were used that night to sedate all the family members.
My lordship, my ladyship, 3 points you have raised. I will certainly answer them one by one. First of all, you have raised that the murder weapon, as we are calling alleged murder weapon, is received from pond on the instance of accused when he was in the custody of police. Means there was a pressure on him to say or to accept.
Counsel, that recovery is under section 27. It is always under the custody of the police only, and that is admissible evidence.
Exactly my point. My lord. This recovery was on the instance of accused when he was in the police custody, so that was pressurized on him.
So
my submission is that is
what
Counsel, try to understand what is the query from the court. It is admissible, I said. And then see, whatever argument you are advancing before the court, it should be either supported by the fact or it should be supported by the law. You can't just come with some kind of theory and make some argument.
Sir, my lord, I'm trying to explain the same thing. It should be either supported,
Time up for pleading.
either supported by the facts or by law. By law, as you said, and I aware it's section 27, but by the facts, if you are saying the acts is nowhere is being seen with the accused before the incident.
Defense, you can do your cross-examination.
Weapon used by the accused itself. Second thing was,
This is not a case of eyewitness, madam.
Panwala's deposition.
Anyways, you can proceed with recording of evidence.
So these 3 questions of yours I need to answer.
I got your point.
Much obliged, your lordship.
Let's start with the witnesses.
Witnesses, sure. My co-counsel will go ahead with that, as the time restrictions, my co-counsel have not got any chance to submit it. So at least she will go ahead with the witnesses.
Good. Good effort for a teamwork.
So, my lordship, I would like to call up the witness, Bilal Ahmed, that is a pawn shop owner.
Yeah, please proceed.
Hello, Mr. Ahmed, am I audible to you? Hello.
Yes. Hello. Yes. Bilal.
Mr. Bilal, my only question to you is, in the testimony before the investigating officer, you admitted that the friends of the accused working with the Aras were talking.
Counsel, you cannot confront with the witness statement. It can be used only for the purpose of contradiction and omission.
Sir, much obliged, my lordship. Other than that, any information you are having?
Hello.
Other than this, Mr. Ahmed, have you said in the statement?
No, no, no.
Okay. That proves that the Salim has purchased the pills, and nowhere it is mentioned that my client, that is accused number 1 and 2, have handed over the same pills to them.
I would like to add here, my lord. With your permission, should I continue further?
Please.
Yes. The point which we wanted to prove over here is, nowhere it is stated by the witness that the pill which was purchased by Salim has been handed over to any of the accused. So if we are saying those pills have used to sedate the deceased, is not proven here. Secondly, it has been, as it is in the case sheet, the fact sheet, it is said that the accused number 2 have attempted to buy the pills. Mr. The Panchov or the Lugade have already said that he don't remember the date, on which date he have attempted to buy the pills. Secondly, he said he is a regular customer of him, regular purchaser of that own shop. We want to prove our point over here, my lord, that first of all, our accused number 2 have not purchased the sleeping pills, so there is no use of sedative pills. Second point is, if Salim have purchased it, that not for the purpose to hand over it to any of the accused. Third point, we have to prove that whatever Mr. Bilal, the pawn shop owner, the blockhead, or the third person pharmacist is saying, these all are hearsay evidence which we cannot really rely on. Fourth thing we have to prove on is, the sedative medicine was not found in all the deceased body. Only 2%, so we can say that might be taken voluntarily. We cannot say that it is given for a sedation. By this all points, we want to say, my lord, that Sarah and Araz, although Sarah and Araz are having a relationship, we want to say the relationship was disclosed already to their family. Even the pregnancy of accused number 1 is already disclosed to their family. Even after that, there is no record found that the family have complained anywhere against accused number 2. They have not complained against accused number 2, means they have accepted the relationship. And once they have accepted the relationship, there is no revengeful attitude. And if there is no revengeful
It is more on presumptive value.
That they haven't made any complaints and they had accepted the relationship.
There is no present complaints have given over here, my lord.
Yeah, absence of complaint doesn't mean
prosecution side have failed to prosecution side have failed to prove it.
Pardon me?
Prosecution side, the side of prosecution have failed to prove it, that they are having an intention or motive. Accused number 1 and accused number 2 is having an intention to actually give a result of such an incident. Prosecution side have failed to prove it. There is no proof, there is no witnesses, there is no eyewitness to prove that accused number 1 and accused number 2 are actually involved in this incident.
Your point some time ago was they haven't made, her family members haven't made any complaint. That was your point on which I was talking, right?
Correct.
Absence of actual legal complaint doesn't mean that they had accepted the relationship. And secondly, it was only after the murder and the brutal incident that it was discovered that she was 2 months pregnant. It was not beforehand that the family members knew that she was pregnant with a 2-month child.
Ma'am, but as you were saying,
I repeat, 5 minutes left.
As you are saying, it is not nobody is there to say that, nobody is going to prove that. There is no eyewitness, no evidence to say that the family is not aware about it. None of the incidents, none of the evidence, none of the document is proving that that family is not aware about it.
So probably, can I put this this way, that the witness, Mr. Lala, right? Mr. Lala Khan, the noise of shouting and the quarrel which he heard on that fateful night could have been of this incident only.
That could have been of the robbers also. Actually, Sarah was crying with the scene, whatever she was seeing, and Lala Khan, I actually want to say Lala Khan is not deposing his things properly, ma'am, my lord, because Lala
You want to listen, you want to say that Sarah was there at the time of incident when the robbery took place, or she was not in the house?
Sarah was there, accused number 1 was there, and she only is the one eyewitness of the incidents which actually happened, which prosecution is trying not to reveal, to hide it, to just
You mean to say the robbery took place without any kind of substantial asset being taken out of the house?
Substantial, you mean to say any valuables?
Cash, valuables.
There is
Sarah being left alive.
There is nobody other than Sarah there to say whether the belongings have been taken or not. Any valuables or any belongings are missing from the house.
That is what I mean to say. Why is only Miss Sarah left alive then? As your witness has said, there were only 2 rooms in the house.
Accused number 1 have already explained that she was in the other part of the house, and when she came back, that time
2 minutes left.
But your witnesses have stated that there are only 2 rooms in the house.
Witnesses have stated 2 rooms only house. My lordship, no, none of the witnesses have stated that there were only 2 rooms in the house. None of the witnesses.
The witnesses have stated that statement.
Complainant has made that statement.
Actually, sorry?
Complainant has made that statement in evidence.
Complainants had made the statement. Lala Khan have made the statement.
Yes, he's the complainant.
No, you have not made.
That's
Recording of evidence he has made. Don't look into the fact sheet.
No, not in the fact sheet, but you are saying evidence means whatever prosecution have asked the question to the Lala Khan, that's what you are talking about. And
Yes.
in that session, he have not said that there were only 2 rooms.
All right. So the
He
court
have
is
not
wrong.
called for evidence of Lala Khan. Prosecution have called for the evidence of Lala Khan, and when prosecution was taking chief examination of Lala Khan, he had not said that there were only 2 rooms. In
All
the
right,
house.
counsel. So you are finding fault with the court recordings, right?
Time up.
No, my lord. No, my lord. It is not so. We are just trying to put forth our case. We are just
All
trying,
right.
All right, okay, fine.
just trying to
Thank you.
find out the justice, my lord.
All right.
Thank you.
Wish you best luck for your
Should I
justice.
go ahead with? Should I go ahead with my prayer?
Yes, prayer is to acquit, right?
Correct. Yes.
All right.
Anyways, with the time concern, we have not got a time to rebuttal also. This is what we have to say. Secondly, we will say that on the very short note, where we have not got the chance still, confession is already done in the witness box. But any of the accused have not confessed before this honorable court.
Tell me under what section of CRPC the confession is made?
Confession is made in this case, or you are saying has to be made?
I'm making you a general query.
General
Under which section confession is recorded?
Okay. Confession is recorded if it is in the police station. If you are saying before investigation agency, it is recorded under section 25 of the Evidence Act and 161 of CRPC. Whereas it is actually to be in front of the magistrate in the witness box, which is 164 of CRPC. And this is what
There's
is
a
not
difference
clear.
between recording of statement and confession, ma'am. Okay.
Right. But the confession is.
All right.
Yes, my lord. There is no any direct evidence, no eyewitness. There is no medical report or forensic report which will build the case of prosecution, which will build a guilt to the accused to the home. This is the case. All things on the point revealed that the story of prosecution is baseless. The reason behind that is prosecution has failed to perform their duties, and just to complete the investigation, they put these 2 innocent persons behind the bar with the help of this baseless and laughable evidence. It is therefore prayed before this honorable court that the base of above said fact, evidence discussed, the alleged put by the prosecution against both the accused are false, fabricated, conquered, without any truth behind the scene. I would like to rest my case, my lord, with the fine sense of a judgment to this honorable court.
All right. Thank you.
Thank you, my lord.
Thank you.
Are we done with the proceedings? Both of the teams are satisfied with their proceedings?
Very much, I guess.
Yes, we will begin with the ending ceremony right now. I will be handing over to Miss Ankita for the ending procedure, our lecturers.
Excellent. Good.
A very good evening. For the wonderful time we have all spent here together over the past 8 hours that has been so enriching and enjoyable, I, Ankita Dogra, on behalf of HVPS College of Law, extend my gratitude and heartfelt of best wishes to one and all present here. I further extend a special vote of thanks, foremostly to Dr. Rajendra Singh, Secretary of HVPS College of Law, to Dr. Usha Mukundan, Director of HVPS College of Law, to IC Principal of RJ College, Dr. Himanshu Davda, to Law Fest Convener, IC Principal, Dr. Mrs. Madhura Kalamkar, our esteemed dignitaries judging moot court competition, Advocate Madhusudan Parekh, Advocate Mayuri Bane, Advocate Anil Gaikwad, and to all the in charge faculties, to all the Law Fest organizing team, and to each and everyone who have directly or indirectly contributed towards making this first day of Law Fest, Vidhi Taksh of HVPS College of Law successful. Further, please take note that the schedule of valedictory function will be announced on 27th March 2021. We'll be announcing our results via email, and therefore we rest this day and hoping to resume tomorrow with double enthusiasm. Thank you once again.
Ma'am, we are done with the proceedings. You can leave this call right now.
Can we leave?
Yes, we are done with the proceedings. We are done for today.
Okay, thank you. What about tomorrow?
We will be informing you on WhatsApp as well as mail. So
Thank
don't worry.
you. Thank you. Thank you.